So good morning, everybody. We're here for a policy meeting on the 8th edition sentencing guidelines. We have a pretty lengthy agenda to get through today, so I'll turn it over. I hope everybody's well. And I did send a note to Executive Director Bergstrom. I feel like the commission has a good skeletal understanding of the broad areas we're going to cover today. So I think we have a great foundation. So I think they're just going to work on putting some meat on the bones. But with that, I'll turn it over to the Executive Director.
Thank you, Judge, and good morning. And I want to thank Matt and the crew for all the arrangements at the hearing or the meeting location in Harrisburg. Just to make sure we have it on the record, I am seeing so far attendance by Zoom, Judge Bernstein, Judge Daly, Judge Tucker, Senator Langerholt, and Representative Krajewski. I believe in the room are Attorney Marsico and Judge Marsico. And I know on the road, on way to the meeting location, are Representative Stevens and Professor Rago, along with Professor Mystic. So if I missed anyone, Matt or someone, just let me know if there's anyone else participating.
You got everybody, Mark.
Okay, great. Thanks, Ryan. So again, thanks to staff. What we hope to do today, and as the judge said, there's a lot of material, but this is not new ground. We've been working on this, I guess, to some degree since 2014. But the hope today is to revisit in some detail this morning the OGS assignments based on the discussions we had at the last policy meeting a month or two ago, and to provide that to the commission, both sort of the framework that we used and the specific assignments we did. And just as a reminder, we have assignments right now for well over 2,000 offenses. And so the idea is to come up with a process that we can use and that the commission has confidence in. There was additional work done, and we'll have presentations, particularly this afternoon, on prior record score and sort of the general procedures moving forward if the commission was to approve this framework or this preliminary draft for public hearings. And let me just be really clear from the start. We are not ready to adopt guidelines, or the commission is not ready, but we've gone through a lot of discussions, and these are substantial changes to the sentencing guidelines. And so the effort, I think, is to try to see if we're ready to package this information and publish it and have hearings in February or March to just start the discussion with the public and others regarding what we're proposing and receive some feedback, so that but in the first half of next year, we can move towards more formal approval of close to final form guidelines and have public hearings on those to move towards adoption sometime next year, with the idea that implementation would be probably the following year. So that's sort of the game plan. Today is just trying to make sure we're on track and seeing if we have enough in place that we can package this and take and at least publish it and have some hearings to start conversations about it. So with that, I will start today with sort of a quick overview, a summary of what we've done to date, and a focus on these OGS assignments. And included with that will be a discussion of what we've called adjustments and enhancements, things that we'd be building into the guidelines to have more consistent sentencing around typical reasons for departure, or incorporating the various enhancements we're required to consider. So with that, Ryan, let's move to the next slide and we'll get started. So here's your refresher in one slide. This is what the commission is trying to do. So first, keep in mind that our guidelines are intended to be a common starting point for sentencing. And the way we frame this, the way we discuss sentencing guidelines in Pennsylvania, is that the standard range recommendation is the typical sentence for the typical offender. So a common starting point based on the typical sentence for the typical offender. That takes into account that courts have great discretion and sentencing is individualized. So the court's looking at individual factors about the case, whether it's the offense or the individual, and determining what an appropriate sentence is. But the starting point is that typical sentence for the typical offender. Also, really important to remember that our guidelines are advisory. We've spent a lot of time, or the courts have spent a lot of time talking about what type of guidelines do we have? Are they presumptive? Are they like mandatories, or are they advisory or voluntary? They're advisory guidelines. So the courts must consider the guidelines. There's some weak appellate review. Courts are required to provide reasons when they go outside of the guidelines. But in the end, these are advisory guidelines. They're supposed to channel the discretion of the court. And the guidelines work basically at two levels. The first type of recommendation we have in place is regarding the disposition of the case. Should it be a community-based sentence like probation? Should it be confinement? And if confinement is at a county jail or state prison. So those are the recommendations in terms of disposition. And then linked to disposition is duration. How long should that period of probation be? How long should that period of confinement be? And so those are the other aspects that we build into the sentencing guidelines. So that's sort of the background. That's been sort of the story to one degree or another since the commission was established in the late 70s and since the first guidelines in 1982. And we've spent considerable time since 2014 thinking about what the guidelines should be today. And so one of the documents that we've posted and made available is this summary of guidelines since 1982. And in there, we try to talk about some of the movement of guidelines in one direction or another, and sort of how we got to where we are right now. And what we've heard from various advisory committees that we've empaneled to help us come up with these recommendations. So we're not just starting, with a blank slate. We're working from the experience of guidelines since 82, and especially from the experience of a lot of practitioners since 2014, as we've done this comprehensive review. So I'd encourage people to look at that document to get a full background of what we've been addressing over this time. So based on all of that, I think we've developed some guiding principles for the development of these 8th edition guidelines. And the first guiding principle is simplify the guidelines and automate them. Make it easier to use by practitioners, easier for people to understand, and easier for the system as a whole. So we want to simplify the guidelines and we want to automate them so that you're not spending a lot of time working on preparing the guidelines. It's a much more sort of fluid system. And the purpose for that is to move towards more consistent and certain sentences. When we started with our strategic planning work group in 2014, both the defense and the prosecution were big on the idea that most sentences in Pennsylvania are negotiated pleas. Sometimes the negotiations are to the conviction offense, sometimes they're to the sentence, and sometimes they're to both. But negotiated pleas are the way justice is done in Pennsylvania. More than 90% of the cases we see are the result, one way or another, of a negotiated plea. And so the parties, prosecution and defense, have to have confidence in the guidelines. They need to have, they benefit from having consistent application of the guidelines and certainty in the outcome. And so that's led to a couple of things that's been echoed throughout the last 6 or 8 years of this review. And it's certainly part of the justice reinvestment recommendations to the commission about guidelines. The first is our guidelines should be much more targeted. When we're talking about offense gravity score assignments, and we're talking about an individual with a with a 0 prior record score, no criminal history. So we're looking at just that conviction offense and coming up with a sentence recommendation. The recommendation of JRI and of the working group and just about everyone else we talked to was be more direct about what your recommendation is. These are advisory guidelines. Courts have discretion to go outside of the guidelines. So be more direct about what your recommendation is. And the first level of that is recommend a specific disposition, not everything under the sun. We have recommendations right now that are, RS to 9 that basically allow any type of community-based alternative and pretty substantial periods of county jail. And with an aggravated sentence, which is part of the guidelines, it provides for state prison. So everything possible in Pennsylvania, almost everything possible, is within the recommended range that we're providing. And so the idea was focus on what the disposition should be. Let courts do what they want to do to individualize the sentence, but have a recommendation that's much more focused. So you'll see in these guidelines, in this effort, it's much more about providing a specific disposition as a recommendation. And then the second part of that is the duration. Our guidelines have a reputation, good or bad, for being very generous in terms of the width of the ranges, how broad the ranges are in terms of duration. And the idea was to tighten that, to have much tighter recommendations. Again, because they're advisory guidelines, give a common starting point, and then let courts decide if that's appropriate or not for the specific case before the court, and aggravate and mitigate or depart from the guidelines as courts are able to do. So these guidelines that we're proposing would have much narrower ranges. The second thing that we heard about was, and this was starting with the strategic planning work group, the prosecutors, the defense attorneys, the practitioners, the judges, everyone that was involved in that process, said that there are common factors that often link to sentence recommendations. And to the degree that they're not built into the guidelines, there can be inconsistency in practice and a lack of certainty. So to the degree that you identify common objective factors, build them into the guidelines. And so we've tried to develop a method to do that. There are ways that things are built into the guidelines already through what we call enhancements, many of those required by the General Assembly. And so we're acting on that, but that's an example of taking factors, sentencing factors, not elements of the crime, but factors, and building them into the guidelines so that there's more consistent and certain application of recommendations related to that. And what we've been encouraged to consider is finding other factors that are common like that and build those in as well, so that those factors are treated equally, or at least in a similar fashion, across the common law. So you're going to see us really building up those enhancements and adjustments to try to address common sentencing factors. And the final sort of takeaway as far as guiding principles was to reduce the impact of the criminal history, the prior record score. Under our current guidelines, there are times when the prior record score can increase the sentence recommendation from the baseline, from a 0 prior record score, by almost 10-fold. And so the recommendation was that we should reduce the impact of the prior record score. And there's sort of two reasons for this. The first is we have historically said that the most important factor at sentencing is the current conviction offense. But if you're allowed to increase the baseline sentence recommendation for that offense by 10 times only because of the prior record score, then that's not consistent with what we say. And so one of the recommendations, a strong recommendation of the academic review panel, was to think in terms of a doubling of the base recommendation. Come up with the prior record score should do, except for exceptional cases like revoc, the prior record score should do no more than double the sentence recommendation of the baseline. So that means we have to look at the baseline assignments to make sure those are appropriate, but then try to reduce the impact of criminal history. And you'll see that we've spent a lot of time this afternoon. Matt will talk extensively about the work that has been done on rebuilding the prior record score. And that includes not only coming up with new categories and a new approach and reducing the impact of the prior record score, but also taking into account the lapsing of prior conviction. So more about that later. The second reason why a reduction in criminal history is really important is because of the racial impact. One of the things we looked at very carefully was the impact, the disproportionate impact of criminal history or prior record score on African Americans coming through our court system. So there are certainly across the board, there's increases in sentence recommendations and in sentences imposed based on an increase in the prior record score. But that's disproportionately the case with Blacks as compared to whites. So one of the efforts here in rebuilding the prior record score is to try to reduce that difference, that disproportionality. If all things are even, then race should not be a contributing factor to an increase in sentence. And so we're trying to, through the prior record score, trying to address that. So much more about these as we go on today, but I wanted to give you that sort of refresher and high level look at what this comprehensive review is all about. Next slide. So one other thing we should think about as sort of anchors for our work is what the statute requires. And for sentencing guidelines, there's actually 3 statutes in play. So the first statute is just our general authority to adopt guidelines and what that says about how we develop guidelines and things we work on. So the first factor the commission is supposed to consider in adopting guidelines is the seriousness of the current offense. That's the primary factor. And the way we do that is through the OGS assignment. So in the past, we had a 15-point scale, and we spent a lot of time trying to figure out what's the right OGS assignment for a given offense. And what we find is there's a lot of detail involved. This gets very granular, very fast. With more than 2,000 offense categories that we consider, the commission spends a lot of time looking at elements of crimes and the grade of the offense and other kind of factors to take into account how to sort of rank these offenses so that the recommendations are proportional, and also trying to package together similar types of offenses so that there is uniformity. So those are 2 aspects of assigning offense gravity scores: proportionality and uniformity. So we do this with those OGS assignments, and many times we subcategorize. That means the commission looks at factors other than those required by the statute, sometimes sentencing factors, sometimes splitting out the statute beyond where it is. For instance, in cases where attempts and completed offenses are part of a single definition of an offense, splitting those out because we might view an attempt as less serious than a completed offense. So that's just examples, but think about the Drug Act, where you have a statutory maximum that's sort of stable based on the type of drug, the schedule of the drug. But there's a lot of differences in what we see as sentence recommendations for small quantities versus very large quantities, or a first offense versus a second or subsequent offense. So the commission breaks those down, gets more granular in the assignments. So that's how we address that first statutory requirement of seriousness of the offense. We try to look at that offense, we try to rank it, we try to employ techniques to try to deal with proportionality and uniformity, and we come up with these various assignments. So the task we have ahead of us with this 8th edition is we're moving from effectively 15 categories to 42 categories. So we're going to talk a little bit about how you do that, and actually what that provides to the commission in terms of making much more discrete decisions and recommendations about these assignments. So check the first box, seriousness of the offense. That's a pretty fundamental part of how we build the guidelines. The next thing in the statute is that the commission consider criminal history. So we call this prior record score, and that the prior record score should increase in severity or intensity based on priors. So we've put a lot of emphasis on really building up the prior record score over time. And this is the one where we want to revisit that. And that this whole process has been about that, and try to really sort of pull back on the weight of the prior record score. But we still have to consider the prior record score. And in the statute, it says that we consider both adjudications and convictions. So we want to think about how we use those and the limitations of using those. And so there's a lot of discussion about that Mel will go into this afternoon. The statute provides that we can exclude or reduce less serious offenses. In the past, we used to, in the 0 prior record score category, we used to sort of provide a pass if there was a single misdemeanor 3 offense. We said we won't count that. But until this language was included with JRI 2, it was questionable whether we could just exclude an offense in the prior record score. But the commission clearly has authority to do that now, to either exclude or reduce less serious offenses in the prior record score. And later you'll see there's other things that we have the authority to do that we didn't have in the past. So this is a novelty that we're trying to build into the guidelines. And then there is, under the statute, there's a provision that says that there should be an increase in the sentence recommendation if the person is under supervision at the time of the offense, or if there's a temporal or offense pattern. So keep in mind that while the commission is spending a lot of time on sentencing guidelines, we also have resentencing guidelines. We're working on parole and recommitment guidelines, and we have the sentence risk assessment. So we have a lot of other adoption responsibilities aside from just sentencing guidelines. And one of the things I think the commission can and should do, because it has these multiple responsibilities, is figure out a way to harmonize everything. And one of the concerns is if something is provided in multiple guidelines, there could be a sort of a double dipping or double down on a provision that wasn't intended. And so one of the things the commission has to think about is, where do you apply this? I mean, let's make sure we are abiding with statute, but let's also think about how we do it. So for instance, if the sentencing guideline statute says there should be an increase if someone's under supervision, well, what happens if someone's under supervision and commits a new crime? In our resentencing guidelines for probation violations, or our recommitment guidelines for parole violations, in both of those cases, we take into account that the person was under supervision at the time. We add that to, that's a factor there. So I think we have to be concerned about adding it in sentencing guidelines and also adding it in recommitment or resentencing guidelines. So one of the things that the staff has argued is that the provision about under supervision does not need to be explicitly in the sentencing guidelines as long as we're addressing that issue in the other guidelines. So that's something for the commission to decide. But at this point, the recommendations for adjustments because of being under supervision are not in place, because the understanding is they're taken care of in another set of guidelines. So this is the harmonizing of our responsibilities. But the second factor there, temporal or offense pattern, is something that was raised early on in this review process and has consistently been in place. The idea that there should be an enhancement, there should be an adjustment to a sentence recommendation if there's a temporal or offense pattern. If someone is doing serial offenses, or there's this pattern of offending, there should be some kind of value for that built into the guidelines. And so that's one of the adjustments we're going to be recommending, that if there is temporal or offense pattern, that the base OGS is adjusted up by a point or two to take into account that provision, that requirement of the statute. So more about that later. Moving to the third category of statutory requirements, it's the criminal behavior provision. And this says that the commission should think about increasing the OGS assignment or the recommendation based on increased culpability. And specific examples provided are when a deadly weapon is possessed or used during the commission of the crime, or when there's substantial harm inflicted. Well, we get at this in a couple of ways. We certainly have the deadly weapon enhancement. And what we recommend in the enhancements that we're going to be recommending or providing to you is, again, this sort of step increase, a 2-step increase if someone possessed a weapon during the commission of the crime, a 3-step increase if someone used the weapon during the commission of the crime. So we're taking what we have right now as sort of a separate matrix for deadly weapon enhancement, and we're just blending it into this step up provision, which is, again, a streamlining and simplification of the process. And it just is a more consistent approach to this. It brings everything together in one matrix. So that's for the deadly weapon enhancement. In the OGS assignments, we've taken a lot of care in trying to make sure that different levels of harm are reflected in different assignments. And this is a call by the commission if those assignments are correct. But the idea is to look at sort of a rank order of harm. You know, start with death as the highest, and then serious bodily injury, and then bodily injury. Think about whether completed versus attempts at that, how that fits in. But coming up with sort of a rank order of harm so that when we're doing the OGS assignments, we're coming up with that sort of proportional assignment based on harm. So that's how we try to address the criminal behavior aspect. Next slide, Ryan. So the guidelines also, or the statute also calls for us having aggravated and mitigated ranges. And, you know, as I guess this makes sense, that they're based on aggravating and mitigating circumstances. And one of the things that we're suggesting is while we continue to have those ranges and courts have the discretion to aggravate or mitigate, we should be looking for common aggravating and mitigating circumstances and try to try to employ those in a more consistent way. And the way we could do that is make that an adjustment. So if there's a common aggravating or mitigating reason, a reason often given for moving in the guidelines, let's just build that into an adjustment. And either it's an adjustment up, a step or two, or an adjustment down. So substantial assistance is sometimes used, and certainly used in the federal system, for a reduction in the sentence recommendation. And so that might be an example of an adjustment down. And then rolling the offense or something like that, maybe public trust, other things like that might be reasons for an adjustment up. So we'll be talking later about these adjustments that really, to some degree, are standardizing certain aggravating and mitigating factors or circumstances. Another statutory requirement, and this has sort of fallen out of, I don't know, view in recent years, but around the time of JRI 1, there was a lot of talk about place of confinement and paroling authority, and sort of creating new boundaries about how are county jails used and how are state prisons used. And the idea about, you know, who should be responsible for what. And so at that time, when our legislation was amended, there was a specific requirement that the commission sort of focus on or report out on the impact of sentences or sentence recommendations on the use of total confinement, and particularly about whether it moves to a shift to county jail from state prison or state prison from county jail, right? So is there a movement of our recommendations? Now, we would argue that with a lot of the recommendations we're talking about, especially in terms of prior record score, the net is a reduction overall, so a reduction in state and a reduction in county confinement. And the increase would be more towards the use of probation or of other restorative sanctions. But even for those, because there's concerns about, are we just dumping down there? That's where guidelines that reduce or try to target the use of probation for more shorter periods of times at times, and really the increased consideration of sole sanctions like fines and community service, restitution, and even the use of guilt without further penalty is sort of built into the guidelines. So more about that later, but we always do an impact analysis with guidelines. We're part of the State Correctional Population Projection Committee, but we should also be thinking about, with these guidelines, how cases would shift based on our recommendations. So we'll be looking at that as well. And then I think finally, at least under the general statutory requirements, there's a provision for risk-related adjustments. And this is a fairly new provision in JRI 2. But we're supposed to make sure that there's incapacitation of serious violent offenders. And so we have in the past created the REVOC category in the prior record score, and we retained that as part of the high prior record score category. We're supposed to take into account modifications to criminal history to reflect risk. So this works in two directions. When there's a diminished risk because of criminal history, we should be addressing that. And one of the common things we've heard from the start is that there should be a lapsing provision for adult convictions, and particularly to try to remove stale records from consideration in the prior record score. And there has been a lot of discussion by this commission regarding how we address juvenile adjudications. We have a lapsing provision. It's relatively restricted. And so the idea is greatly expanding on the lapsing of juvenile adjudications. And Judge Tucker is taking a lead on this. We've worked on this issue a lot, and Matt will be talking about that this afternoon. But clearly we have the authority to provide for lapsing in cases, especially of stale records. The second category, though, works in the other direction. And it talks about adjusting the duration of confinement based on serious criminal history. And so the commission has in the past created the RFL category, repeat felony 1 and felony 2 offender. And the commission retains that in this recommendation, again, as part of the high category. So when you look at the high prior record score category, there are sort of two divisions, one that defaults to the RFL and one that defaults to the REVOC. And those address these risk-related adjustments that we talked about. Next slide, Ryan. So in addition to those basic provisions regarding our sentencing guidelines, we then have other requirements in statute. For instance, we now are required to do probation guidelines, and the probation guidelines are supposed to consider the duration of terms of probation and then the use of county intermediate punishment programs as restrictive conditions. So we have built that into these guidelines. During Amendment 6 of the 7th edition guidelines, we introduced the concept of duration of probation and sort of aggregate probation terms. We have always had sort of the trade-off provision for the use of county intermediate punishment in the past, where we provide the trade-off for drug treatment in lieu of incarceration. And we also provide the day-to-day trade-off with general restrictive conditions like house arrest and electronic monitoring with county jail terms. So those have been in place. We continue to build that into these new guidelines as a way of providing guidance on duration of probation and the use of restrictive conditions. There's a separate provision of statute about the guidelines for restrictive conditions. And in there it says that when we're thinking about these guidelines for restrictive conditions, we should give primary consideration to reducing recidivism in order to protect the public. And also, this is the provision that includes that certification of compliance with the guidelines. this is our requirement to certify county compliance with the guidelines and the full reporting of data to the commission. And then finally, wrapped into these guidelines is a separate provision of statute where we're required to provide guidelines for fines. And there are two aspects to this. The first and sort of leading aspect in the title is that the guidelines for fines authorize or prescribe or suggest a range of lawful economic sanctions. And so, especially at the lowest level, level A, which is other restorative sanctions, and then moving into B, where we have probation recommendations, we really are trying to build up, have more visibility to the idea of fines and community service as standalone sanctions or as primary sanctions linked to almost non-reporting probation. So trying to give more emphasis to this provision in our mandate. And under the guidelines for fines, we're authorized to prescribe community service as an alternative to fines. So that is built in. And in fact, the structure we use is we prescribe or recommend hours of community service as sort of the first recommendation, with the idea that fines could be determined based on those number of hours along sort of a day fine system approach. So, so that was a lot of stuff as far as background on the guidelines. So I probably need to take a break to breathe, and you may have questions. So how about if we just sort of open it up or turn it back to Judge if there's any questions just about this sort of preliminary overview stuff.
If anybody has any questions, just unmute and state your name so we know who's chatting, since we're kind of all over the place. Anybody have any thoughts or questions? Besides me. I'm going back through my notes because there were a couple of things that I wanted to ask. These we can address later more with a prior record score, but while they were on my brain, just because we're going to be putting out these eventually for the public, when we were talking about criminal history as a factor and the PRS and the up to 10 times, I think that the general belief certainly is if you did it before, you're going to do it again. And so just what kind of support do we have to show why we're doing what we're doing? And then also, I picture there will be certain people out there in the public who are going to say, well, who is this academic panel? And maybe I'm picturing, we're going to have different camps to the left or the right. And this strong leaning for the 2 times, and just curious what objective factors were put into that. So those just are things I assume we're going to discuss, but I picture those being big public issues.
Yeah, thanks, Judge. I think the starting point is Matt will go into greater detail on this afternoon, and hopefully he can pick up on some of those points. Let me just give it a couple initial reactions though, or comments. One is that when we did research on our current prior record score, and it was not only our research, it was research done by Carnegie Mellon University and others. We're trying to understand sort of conceptually, like, why do we have prior record score? What's its purpose? How does it work? And in the research and from the start of having sentencing guidelines in the United States, there were 2 justifications for having a prior record score. The first was retribution. And so that's along the lines of what you mentioned in terms of, you've been here before, you're back again. There's a higher level of blameworthiness because of that. And so just from a retributive point of view of holding someone accountable and a repeated offender different than a first-time offender, the prior record score is justified. So having a prior record score is justified based on that. The question is, how much weight do you give it? And we've been really generous in giving it a lot of weight. And in some cases, we'll continue, like I said, for RFL and REVOC, especially REVOC, we will continue to give a lot of weight to prior record score. But that's an exceptional case. And the typical case we should try to think about what rules apply. So on retribution, in terms of holding someone accountable, there should be a prior record score. And the question is, how much weight do you give it? And that's where what the commission has said since the start of the commission in the early 80s is the most serious factor, the factor driving the sentence recommendation should be the current conviction offense. And if that's truly the case, then we have to really think about how much weight do we give to any criminal history. The person was sentenced for that previous offense, was sentenced on that previous offense, and arguably has completed that sentence, whether it's probation or confinement. And now we use it as an enhancer for the sentence recommendation. We should not be resentencing them for their prior conviction. We should be taking into account that they do have a prior conviction, and it's built into this. So that's why the discussion is, how much weight do you give it? So that's on the one issue of retribution. The second issue for prior record score is about risk. So the second justification for having a prior record score is it's an indicator. If someone's committed an offense and they're back in court, maybe that foretells that they're going to commit future offenses. So it's a risk factor. It's a risk indicator. And clearly in our work with risk assessment, we found that prior convictions, prior arrests, but certainly prior convictions were correlated with an increase in future crime. The problem was with our current prior record score categories, we're sort of mixing apples and oranges. We have this sort of hyper-technical way of determining how you calculate a prior record score. And in the end, we end up with a lot of things sort of in separate boxes that sort of have the same profile. So it's sort of more complicated than it needs to be in terms of risk of reoffense, so recidivism rates. And Matt and others have done a lot of work on this. CMU did a lot of work, Penn, Drexel. We've had a lot of people working with us on looking at this. And the takeaway is, you could simplify it. You could come down to sort of more categorical approaches to prior record score that might be better reflections of risk of reoffense. And so that's what we found sort of with this new approach. Having a 0, low, medium, and high gives us a better sort of stair step in terms of reoffense, of risk of reoffense, recidivism. And so we now see, I think, better distinctions between the levels that we've had. So the commission's decision, if you think the framework works, is how much weight do you give and whether you're capped at double or you go higher than that. But I think there's a good argument that if prior record score is a secondary factor, then we should be bringing down the weight of it. And we figure out what are the exceptional cases like revoc, and that would truly be an exception. Otherwise, we think about how we adjust the current OGS assignment if there are factors that are part of the prior record score now that should be considered as part of the current conviction offense. And that's why factors like the pattern behavior is important as an OGS assignment or an adjustment. Because right now, one of the justifications for prior record score is, oh, this person has this pattern of offending. Well, how about if we take the pattern of offending and we make it an adjustment on the OGS side? So that for a current offense, if you have this pattern of behavior for burglaries or for sex offenses or for drugs or whatever, that there's an adjustment there. So we're capturing that concern, that issue about retribution by adjusting the offense gravity score. And the final thing I'll say about this, I know I'm rambling, is also, especially with drug offenses, one of the things we have not done in the past is we have not distinguished if someone's a first-time offender versus a second and subsequent offender. But in statute, there's a distinction. There's a doubling of the statutory max for a second and subsequent offender, but we do not address that in the current guidelines. So one of the recommendations under these guidelines is we do that for OGS assignments, we distinguish between a first-time drug conviction and a second or subsequent that has a higher statutory max, because that takes some of that stuff from the prior record score, the reason to justify the big prior record score, and brings it to the current conviction offense. So we'll talk more about that with adjustments and enhancements, but I hope that lays out at least the reason for doing it. And then it's really the commission's call on sort of the metrics, how much, but that's the background, and Matt can go into detail and cover more questions this afternoon on that.
Okay, and then Representative, I'll see you, so I'll call on you in just one sec. And my point is, and I know you've gone through that for the commission before, and I understand that, but you understand this much more deeply because you live it every day than we do, and we understand it much more deeply than the public. So my point really was just how do we present that in a manner that's less complex? And then I'm going to go back to the representative, and I just have one other non-related but question for now. So Representative Krajewski, if you're good to go, unmute.
Yes, thank you. Good morning. Thank you, Judge.
Good morning.
Good morning, Mark. My question actually is kind of picking up on where you left off in regards to sentencing with drug offenses. Could you speak more to where in the kind of overview we'll dig into substance use and how that impacts adjustments or mitigations? And part of what I'm curious about is particularly drilling in when we talk about like technical violations, probation, and how substance use impacts the recommendations from there. And I asked because I had read the report that the Sentencing Commission had done with Vital Strategies in regards to substance use and how it impacts probation sentencing and some of their recommendations around evidence-based treatment. So I'm just curious about where we'll have the opportunity to dig in more with that.
Great, thank you. That's a great question. You've raised that a number of times, and we've had some discussions, but we deserve a lot more discussion about it. Generally about substance use, there's a couple of things that I think we're trying to build into the guidelines, and some of these things are already built in. So it's a good reminder that some of what we have is good and we retain it in these guidelines. So let me start with that in terms of under the current guidelines at level 3 and level 4 of the guidelines. So basically county jail sentences and the lower tier of state prison sentences. The commission since the mid-90s has built in a trade-off for drug treatment, clinically prescribed drug treatment in lieu of confinement. So we have built in a structure that says, if you're a drug-dependent offender, while we're recommending confinement, we have a structure in place to try to identify drug-dependent individuals and to provide an alternative to incarceration that involves clinically prescribed treatment. And to show the efforts that the commission went through in the 90s to really build this policy, we worked with the Department of Health at the time when they were developing the PCPC, the Pennsylvania Client Placement Criteria, to make sure that we were using appropriate evaluations, assessments, instruments to try to make sure that we're coming up with good clinical recommendations that address the needs of the offender in terms of treatment in lieu of confinement. And the trade-off that we allow basically takes the sentence recommendations, which are retributive, which are about periods of confinement, and puts those to the side and says, instead of whatever that is, if this is a clinically prescribed treatment plan and the court agrees to it, treatment totally replaces confinement. So that's been in place, and the extra step the commission took in the 90s that's continued to this day is we linked the enactment of those guidelines to funding from the General Assembly with the imprimatur of the governor. So right now there's I think $18 million a year for county intermediate punishment, most of that being linked to comprehensive drug and alcohol treatment. So that's a built-in provision to address the benefits of treatment, and it targets specifically people that would be otherwise in county jail or the lower tier of state prison. That same option is available below that for people on probation who are drug dependent, to provide not necessarily the funding, but the treatment alternatives available to the court. So I think we're all in on that. There's always more we could do, but I think we retain that in these new guidelines. So for county jail, for the band that deals with county jail or the lower tier of state prison, that trade-off will continue to be available, trading off the use of restrictive conditions of probation with confinement. And that's certainly consistent with the work of Vital Strategies. What Vital Strategies did beyond that was really focus on revocations of probation and what happens with those. And so when we deal with modifying the resentencing guidelines, we have to make sure we apply those same principles there as well. But I think that's a really key point. The last thing I'll mention, if I could, just the last thing I'll mention is this new structure, we're building in adjustments to the guidelines. And you can think about adjustments in the increasing sense in terms of like enhancements, where we say, because this factor is present, there should be an increase in the sentence recommendation. But adjustments can move in the other direction, where they reduce the sentence recommendation because of a common factor, a sentencing factor. One of the factors that is used with the U.S. Sentencing Commission, and one of the common reasons we see for mitigated sentences, is drug dependency. So one of the things that the commission could consider as an adjustment is something related to drug dependency as a mitigating factor. The only caveat I'd provide is we also see drug dependency listed as an aggravating factor. So you have to take into account how you do that, or if you do that. The other thing that we've talked about before, and we should try to maybe emphasize in the guidelines, is the appropriate use of problem-solving courts like drug treatment courts. In the amendment to the last guidelines, we emphasize that in a greater way. We emphasize the use of risk and needs and responsivity to sort of look at the appropriate use of treatment or other types of non-confinement options, but maybe we can do more with that in terms of sentence recommendations.
Thank you, Mark. Just a final point on that. I appreciate the overview. And I think maybe part of it too, maybe just, and this might be part of like the outreach and kind of education piece with the revision of the guidelines, but even just letting courts know about these kind of evidence-based options generally. Because I think one of the things that also stood out when I was going through the report was the discrepancy around the, it's what seemed to be some pretty promising results when using evidence-based treatment versus how many applicable offenders actually receive that recommendation for treatment. And so just thinking through what can we do to reduce that gap so that we actually see the lower rates of recidivism that obviously we all want. So thank you.
Yeah, and just on that point, one of the other big changes from JRI 2 was to build in and sort of restructure the provision of treatment and various programs at the Department of Corrections. So even if someone is committed to the DOC, there is now more focus on giving the DOC the ability to determine things like the use of what used to be called state IP is now called the State Drug Treatment Program. So in the past, there was procedural issues that made it sort of difficult to get people into the program. Under the new provisions, courts basically designate eligibility or ineligibility, and then the DOC has a lot more latitude based on evaluations during classification to place people into that kind of program. So I think that's in linked in with what you're suggesting in terms of a greater focus on treatment and services for drug dependent individuals.
Yeah, excellent. Okay, yeah, that sounds great. Thank you, Mark.
You bet. Hey, Judge, you're muted.
I know that. So along with it, I said, thank you, Representative Krajewski, first of all, and along with the DOC's state drug treatment, there's also boot camp, which addresses a lot of issues, including drug dependency. And I think you may know this, but the reason that they turned that back over to the Department of Corrections is I think a lot of jurisdictions were underutilizing those programs. So Senator Langerholtz, you have your hand up. If you have a question, go ahead. And you're muted in case you're there and forgot to push the microphone.
Okay, got it. Thank you. Thanks, Judge. Let me lower my hand. Just a question, Mark, just if you could maybe elaborate a little bit on the probation guidelines, and then also with, you're talking about using facilities differently across the state, but, and I temper that with and I don't want to say a movement, but some of the stuff that we passed out of the Senate Judiciary Committee about a month or so ago. And I think there's an appetite, I don't know how far it goes, but for probation reform. And I'm wondering if you were aware of that, and specifically maybe cleaning up some of the technical violations and kind of making it less, I don't want to say punitive, but to address those probation violations. Are you aware of that? And has it kind of factored in, and maybe kind of elaborate a little bit on those probation guidelines, please?
Great. Thanks, Senator. Great questions. I have had discussions, over the year, and certainly JRI 2 talked a lot about duration of probation violations. The research we did with Vital Strategies hit that. I've had some discussions with Mike Cortez, counsel for Senate Judiciary, about the legislation that's been there. And I think a number of years ago, I testified on an earlier version of that bill. So here's a couple of things just to think about and how we try to address some of this. So, one aspect of several of the bills under consideration, and I think the leading one of the Senate, is effectively caps on the use of probation. And, at the same time, the commission only recently received the mandate to provide probation guidelines. So I think it's a legitimate area of concern and of interest and inquiry in terms of, what do we do about probation? Why these really long terms of probation? What about violations and technical violations, et cetera? So all good issues. And I think the question is how do you make some progress on this? And I think, given that the commission has only started to work on probation guidelines with the last amendment, I think you'll see that these recommendations really greatly expand sort of the role of the commission in setting guidelines for probation use. And the commission's position over the years has generally been it's a good first step, and maybe a better step all over, to build things into the guidelines, like through enhancements or through probation guidelines, so that judges retain discretion. They can look at individualized cases, but you're at least directing the attention of the court towards a given policy or practice. So the idea of having probation guidelines in place, and much more specific and directive probation guidelines, I think could be a good first step, or a good response before moving to put in place something akin to a mandatory, where there's a cap on the use of probation. Because I think what we found with mandatories throughout the years, they can serve a really useful purpose for a number of cases. But they're sort of a one size fits all, and there's sometimes unintended consequences. And putting a cap on cases may lead to a case where a longer period of probation may have been justified. It may be an exception to the rule, but it may be justified. And if there's a cap, you have a tough time doing that. The other thing we see is, courts figure out workarounds, not courts like judges, but the whole court system, the working group prosecutors, defense attorneys, judges, and others sort of figure out workarounds. And sometimes that leads to, convictions for higher offenses or to jail terms instead of probation, because there's now this cap in place. So there's sometimes unintended consequences. So I think there is some benefit to, sort of looking at what we're coming up with as far as these recommendations for probation and trying to make the most of this possibility. So that's sort of the one aspect of the legislation about sentencing and caps on probation, things like that. I think the other aspect you mentioned then is about revocations of probation. And again, we have fairly new probation revocation guidelines, or resentencing guidelines. So we're early in the process, and it might be helpful to sort of see how they're working before requiring and putting some things in place. I have to tell you, I looked at the legislation. I think there's really positive things, especially in terms of, drawing attention to concerns about technical violations of probation and sort of the revolving door that keeps someone sort of in the system. But there's also, that concern about, judges trying to do the right thing and individualized sentencing and exercising discretion and putting another factor in play. And here's the example that I hear from judges, and I think it's worth, consideration by the Judiciary Committee. And that is that you have a judge at an initial sentencing where the recommendation is, let's say, county confinement, and the court decides to impose probation, maybe probation with restrictive conditions, but the court, is trying to keep this person in the community. So the court's mitigating from the guidelines, or maybe departing below the guidelines to accommodate that. And maybe that's blended with treatment and other stuff like that. So the court's doing, a really good job of like individualizing the sentence. And then things go off the rails, and the court's trying to like get control of the case and of this individual, keep the person on the path. And then there's restrictions about what can happen because the court placed the person on probation. There's restrictions on the use of restrictive conditions. And so that's one of those sort of unintended consequences. If courts look at that kind of scenario and they say, well, if I place someone on probation, that's sort of a risky case, and things start going off the path, my hands are going to be tied on what I can do. Maybe I just go with a short confinement sentence and deal with this person on parole, county parole. So I just sort of point that out because I think that's a concern. So in any legislation, if that issue was addressed in terms of, well, what was the initial recommendation and what did the court do? I think that would address some concerns that I've heard from judges and others about the restrictions of resentencing. So again, sorry for the rambling response, but I hope that answered your question.
No, thank you. Thanks, Mark. Thanks,
Thank
Judge.
you. And hang on one second, I'm sorry. So we have another hand up. I believe it's DA Sunday. So if you want to go ahead and address the committee.
Thank you, Judge. Hey, Mark, I have a quick question for you. This is with regard to state drug treatment program. Have we seen any increase that you know of with regard to DOC participants in the state drug treatment program after, like, since it has departed from state IP?
Yeah, I'm glad you raised that. I know you raised that before, and I passed on your question or an inquiry to the Department of Corrections. And I think the initial response I got was that, in fact, I think SIP or state drug treatment numbers are up because of the change in the process that's in place. But there's also sort of this competition, I guess, among various programs DOC has now in terms of boot camp and other things like that. So I did talk to them, and I know the preliminary feedback was, I think, consistent with what we talked about before, that there's generally an increased use of state drug treatment program. And maybe there was a drop off in the use of boot camp, but the DOC is also trying to like reformulate all of that based on the new legislation. The one, huge caveat is COVID, right? Because all of this stuff changed, and then we, went into all of the reductions in court processing and that kind of stuff. So there's like a smaller pool of cases that DOC is working with. So, you got to sort of test this back in the real world when we don't have all the COVID issues in play. But what I can do is maybe ask the DOC to address that specific issue, either in tomorrow's meeting, or at least get something to us that I can share with you and with all the members. But I think based on what you've asked before and my discussions with DOC, it's on a positive track. And then what would be helpful is know a little bit more about who those cases are. I mean, how do they differ from what was in place before?
Thank you, Mark. I appreciate it.
You bet. Thank you.
Thank you. Any other questions? Okay, so just one thing, and I'm just throwing this out. We don't need to talk about it now. This is just from my practical experience in our little county, and sometimes when I run into judges from other counties. Is there a possibility, and this is just to think about, to make a requirement for CJEs and CLEs regarding, if we adopt this change, first of all, regarding this for a couple of years, and then an ongoing credit or two, just like we have ethics requirements, we have that other requirement pre-COVID that 4 of our credits had to be from a particular selection of, because as complex as all of this is, day to day, I see people who are still reverting back to what they were doing when they started because they don't understand this. And it's hard. So my suggestion is, if we are able to do that, because no matter how terrific we create this, if it's not being implemented correctly or at all, it's not serving its purpose. So my suggestion is, if we could make that something mandatory, maybe at least for those individuals who have some or all of their practice in criminal law.
Sure, Judge. Thanks for that recommendation. We can try. Clearly it's the call of the CJE board and the CLE board. And as you said, for most of those cases, the only requirement is the ethics, aside from the number of hours, the only requirement linked to ethics. But we can at least discuss that. Ryan will be talking tomorrow about some real great work that he and his unit have done, and some updates about CLEs. And so I'm going to just wait until tomorrow that Ryan can talk about that a little bit more. But I think there's some opportunities. Let me just say that if we start to move forward on public hearings, one of the things we will do is reach out to all of those various agencies and associations that we usually do and look for opportunities to get on the agenda or to do presentations. Just yesterday, Ryan and I did a sentencing update for the PBI, Pennsylvania Bar Institute, and it was limited to this discussion, the 8th edition guidelines. And I have meetings scheduled in the next couple of months with the Juvenile Court Judges Commission and with others. And so, and recently I did a presentation for the public defenders. So we'll look for opportunities to meet with the trial judges, with the president judges, with the District Attorneys Association, and with others. I think Ryan's doing a presentation for PCCD, for the CJABs. So we're going to try to get out there and do this, but mandatory requirements for training is a great idea, and we'll at least ask. So thanks.
Thank you. And Judge Dowell, you have your hand up. Go ahead.
Thank you, Judge Bernstein. I just wanted to second that suggestion, because I think that's a great one. And perhaps, not to get too far out over our skis here, but maybe at the appropriate time, the judges on the commission could send a joint letter to the Education Committee, and express that wish, because I think it's really important, and also for new judges school as well. But thank you.
Thank you, Judge. Any other input? Judge Tucker?
Yeah, I join with that. I think that's an excellent suggestion and an idea that should happen. And I think through AOPC, as a matter of fact, there was a course yesterday on ethics. So they had the mandatory AOPC courses quarterly, I think it is. In any event, I think it's an excellent idea and it should happen. And it's done individually in different judicial districts. Like here in the First Judicial District, we are certified and we have courses at least 3 or 4 times a month on various items. And I think this would be a great topic since we have somewhere in the neighborhood around 40 judges sitting in our criminal section.
Thank you, Judge Tucker. Any other questions or comments before we move forward? So, Executive Director, despite your wanting a breather, I think every time we ask a question, we re-exhaust you, but you're back on.
Okay, thanks, Judge. And I'm going to just do one more slide, and then I thought we'd take a break, and then we'll reconvene for sort of the second half of the morning session. So the next slide is just trying to think about what staff has done since the last meeting and bring you up to speed on that. And then we'll sort of transition into a discussion of these OGS assignments. So I think one of the documents that I sent to all members with a description, I think this was for your Thanksgiving consumption, was a sort of a revision to the draft matrix that we've been working with. And so I just wanted to, at a pretty high level, discuss this. And then this afternoon, when Matt's talking about criminal history prior record score, he's also going to provide some fairly detailed sort of case studies, examples. And as part of that, he'll discuss in a little more detail the matrix, like going through the matrix, the recommendations, and so forth. So this is just intended to sort of point out what's different from the last meeting we had with that matrix and why we made some of these changes. So pretty high level, but plenty of opportunity this afternoon to talk about it in more detail. So let me start with the sentencing levels. So those are those color bands that you see. Under the proposed guidelines, we move from levels 1, 2, 3, 4, and 5 to levels that are based on dispositions. So at the bottom of this matrix, the white band is other restorative sanctions. So fines, community service, restitution, guilt without further penalty. The next band, the light green, is probation, exclusively probation, based on the duration of probation. And when there's prior criminal history, things like that, there's either an increase in the duration of probation or there's the addition of the use of restrictive conditions. So that's the increasing the intensity of probation. So that's the second level, that light green. The third level then, C, is for county confinement. So we've really expanded this section. I mean, this is what you saw last time, so there's no change since last time, but the whole idea here is to have a lot of steps at the county confinement level, pretty narrow bands, and take into account those adjustments that might happen as a result of that. So much tighter recommendations around the use of county jail. Then the next area, the light blue level, is about it's sort of our transition zone. This is where presumptively these are state prison sentences because the minimum period is 12 months or greater. But you know, certain counties may use their county jails for those types of sentences because they have capacity. So this is sort of that blended zone, and we see this as sort of a transition zone, moving from exclusively county jail sentences or recommendations to exclusively state prison sentences or recommendations. So then the next level of blue, I don't know shades or hues, but the darker blue that follows is a state prison level. So A, B, C, D, that looks like E is that state prison level. And then what we added, the dark blue level, is a new level, a level F, that addresses what we sometimes call super felonies. You know, there's a bunch of felony 1 offenses that have a statutory max of greater than 20 years. And we sort of blend these in a lot of different ways. In the past, we said they should all be OGS 14. But then once in a while we put them in 13. But the bottom line is there are, you know, a growing list of offenses, or there is a growing list of offenses that have this maximum period of more than 20 years. And so we thought it might be helpful to, you know, add this as a separate category, sort of the top tier of state confinement for those types of sentences. More about that later. And then at the very top is what we had in the last matrix was murder 1, 2, and 3. But this is sort of, we're reverting back to our current guidelines where we have an OGS 15 that's just for murder 1 and murder 2. And it's particularly so that we can, you know, better capture that kind of information across the board, but particularly build in the recommendations for individuals under 18 years of age. So, so we've sort of gone back to that, where that top level, which we've re-leveled as H for homicide, that top level is for murder 1 and murder 2, and it has the 6 categories. You know, the 2 categories for those that are 18 years of age or older, 2 categories for 15 to 18 or 15 to 17, and 2 categories for 10 to less than 15. So that is that new section there. So that's the difference in the levels. It looks a little bit different, but we think it might be helpful. So we can talk more about that later. The second thing is the OGS categories. So last time you saw this chart, there were 35 general categories, non-homicide categories. And then we had built murder 3 into that top category. But what we've done now is, again, that top category has 6 categories just for murder 1 and murder 2. Murder 3 then is in that super felony category, so in that dark blue band. So we've actually gone from 43 categories to 42 categories, 36 of them below the homicides and 6 of them in the homicide range. And some might wonder, like, why do we call that top thing H instead of like M for murder? And the thing is, M is also for misdemeanor. And so in sort of the data world, you want to have like one letter that symbolizes something. And so H for homicide is being used for murder 1 and murder 2. And M we continue to reserve for misdemeanor offenses. So just a little FYI on that one. One other thing that we did related to the offense gravity score is that we did a little bit of an adjustment to the omnibus score. Remember, the omnibus OGS is like the default value. If the General Assembly enacts a piece of legislation and creates a new offense, this is the default OGS assignment until the commission decides to change it if the commission wishes to. So during the last meeting we had in that matrix, the OGS score for an M2 was an OGS 5. And we're suggesting that we drop that down to an OGS 4, because then there is some latitude in the court mitigating down to probation, I'm sorry, down to other restorative sanctions, or aggravating up to 12 months, which is sort of a typical default for probation, a 1-year probation. So we just think it's a better fit that takes into account that they're aggravating and mitigating ranges, and there could be adjustments to an offense that moves it up or moves it down. So that's a minor difference there. But the character of it remains the same, that the default for an M2 is a probation recommendation. And then up for the super felonies, the offenses with a statutory max of greater than 20 years, we recommend moving that from an OGS 24 to an OGS 28. And part of that is, looking at how we rebuilt the guidelines with that new category. We didn't want to put super felonies up in that new category, but we wanted to get them closer to that. And it just seemed that an OGS 24 assignment was relatively low. And so as a default, moving it to 28 seemed to make more sense for these very serious offenses. So those are some of the sort of structural changes. Within those, we did a little bit of other adjustment. Like, for instance, in that light blue band, that transition zone at D, we narrowed the range a little bit. It was, I believe, 6 months, and we narrowed it down to 4 months because we wanted to transition from those very narrow ranges from county jail, which are like 2 months, to the state prison cells, which are, I think, 12 months. So we wanted to have a little bit better sort of smoothing of it, a better transition. So we changed those recommendations. So the base recommendation remains the same. It's just the width of the range changes a little bit. So there's other changes like that. Finally, on this matrix, we looked at the the aggravated and mitigated ranges. And if you remember, the last time around, we were doing this like 1 or 2 step increase or decrease. And that was wonderful, except it really got complicated when you're moving across zones because the stuff changes, and all of a sudden there'd be these big jumps or big drops from like just based on aggravated and mitigated. So it's like we were working too hard to build a step process into aggravated and mitigated. And so we decided to like go back to where we are, right? So to go back to the current guidelines where we basically have some period of duration, and we decided to link that duration to the disposition that level applies. So if you look at this, starting at the very bottom at level 1, where the disposition is other restorative sanctions, and the primary focus is on the number of hours of community service, the aggravated mitigated really relates to those kind of hours of community service, an increase or decrease in the number of hours as a mitigated or aggravated range. The next step up is probation. And so we have a recommendation about an increase or decrease in the duration of probation as an aggravated or mitigating factor. And that's plus or minus 3 months of probation. Next one up is county jail. And so there it's plus or minus 6 months. I'm sorry. Yeah, I'm sorry. I looked at my wrong notes. Back to the probation. Under the current guidelines, it's plus or minus 3 months, but that's 3 months of confinement. Under the proposed guidelines, under level B, it's plus or minus 6 months of probation. So that's the aggravated and mitigated. When we move up to county jail, under the current guidelines, it looks like the confinement is plus or minus 6 months. What we've done is really cut that back to 2 months because, again, we're trying to have much narrower ranges and much more directed recommendations. If we have too wide a range for aggravation and mitigation, you really do start blending the people into probation, or you blend them into what could be a state prison sentence. So we wanted to keep that pretty narrow. Moving up to that transition zone of D, it's right now, arguably, right now it's plus or minus 9 months. We're looking at plus or minus 4 months as that transition point. And then when we get to the state prison E, it's presently plus or minus 12. We're recommending at that level, I should say that plus or minus 12 for state prison is all of state prison. So everything else that we have, right? So what we're recommending is the lower tier of state prison at level E be plus or minus 6 months. Then that new super felony one be plus or minus 12 months. And then the homicide category be plus or minus 24 months. so that we sort of spread out or provide a little bit more proportional categories for aggravation and mitigation. So that's sort of those are the changes to the matrix that we built in. Happy to discuss any of those. The final thing at the bottom of this slide is what I call off-grid, which means it's not part of the matrix, but these are those adjustments and enhancements we've been talking about. So the idea is based on the initial OGS assignment for an offense, there will be adjustments to the sentence recommendation to the OGS assignment based on these other factors being present. So for instance, with enhancements, we would be increasing the OGS based on a factor being present. One of the other ways we do that is we subcategorize the offense. So under the current guidelines, there are certain enhancements that we just build right into the assignment. So if you look at, for instance, burglary, the commission gives different OGS assignments for different types of burglaries. And one of the requirements we have is to provide an enhancement for the home invasion burglary. Well, that's our top category of burglary. So we make sure that we have a higher sentence recommendation and OGS assignment for that offense as compared to all other burglaries. So that's our way of enhancing that. That's a subcategorization of that offense, or an example of how subcategorization works. The alternative to that, or a different approach, is what I mentioned before about deadly weapon enhancement. You commit a crime, you're convicted of a crime that that an element of which is not a deadly weapon. Deadly weapon does not have to be possessed or used for a conviction of that crime. But if you did possess or use a weapon, that's where the enhancement kicks in. And what we'd say is take that base assignment and add 2 or 3 steps based on whether it's a possessed or use of a deadly weapon. So later this morning, we'll go into some detail on these adjustments and enhancements and see if there's others that we should be considering, but give you sort of a heads up of the work we've done since the last meeting on that off-grid category. So with that, I'll turn it back to the judge, and
Thank you.
and whenever we're done with questions, we'll take a break.
We have a question from Judge Marsico. So Judge, you can go ahead and fire away.
Thank you. Mark, we're scrapping the whole 2 steps mitigated aggravated. Is that what I'm hearing?
I think so. It was just really complicated at those like transition zones. It was inconsistent, and it just seemed to us that just having like a specific number of months to sort of build aggravated and mitigated was just an easier implementation.
I guess my only concern would be, and I talked before about, these narrowly tailored boxes really somewhat limit, I think, judicial discretion. Before, I think a big change now is with the state confinement with your level E, where before, if it was plus or minus 2 steps, if I'm doing the math right, it was about plus or minus a year. Now you're taking it down to plus or minus 6 months. I don't see that big a change with the county confinement. But I do with the state confinement, and that's where there might be more aggravation or mitigation. Just a thought.
Sure. And Judge, that, this is the first time we're sort of rolling out the month recommendation. So we're very open to any kind of adjustments. I know Matt and I had discussions about, what should we put as the starting point for this? And these seem to sort of fit in terms of, what's the width of the range, what's the step up, step down. But if we switch over to months, we're very open to any recommendations or suggestions, direction from the commission about changing those values. So in this case, moving from 6 to 12 months, or 6 to 9 months, whatever you'd want is that makes sense.
Any other questions? And one last thought that I have for later discussion is the possibility of something that gives non-exhaustive examples for aggravated and mitigated, as well as non-exhaustive examples for going outside the guidelines. I think a lot of reasons judges hesitate to do that is they're concerned about being reversed. But I know there's case law at least that shows examples of reasons that they were done and why those were upheld. So I think some direction on that would give the bench a lot more comfort in going above or below. So just a thought.
Judge, it's a great thought, and it's I hate to say it's not original to you, because I think that that has been a discussion point since the start of the guidelines in '82 or before that, because the initial draft of the guidelines included a non-exhaustive list of aggravating and mitigating factors, and so that's sort of I don't know, ebbed and flowed over the years, and that's certainly something we could do. As I think you know, in the annual report, we sort of create a list of what reasons are reported to us for aggravation and mitigation, and we know that sometimes certain judges will have that on the bench because we sometimes receive mitigated reasons being like number 6. It's like, well, what's number 6? And we find out that it's from our annual report list. It's the 6th list of aggravating or mitigating factors. So we can certainly do that. We can always add that to the commentary in the guidelines, in the implementation manual, so that there are lists like that. So however you'd like to proceed on that, we'd be happy to do that. And that would be, I think, considered as part of what we do with these adjustments, because the idea of the adjustments is to identify some of those common ones and sort of lock in a value for those. And then we still want judges to have the discretion to aggravate, mitigate, depart. And so if it's helpful to have example, non-exhaustive list, we can build that into the text, or we can build it into the commentary.
And I knew it wasn't original. Many of my thoughts are not, but it
It's a
hasn't
good one,
been,
though.
it hasn't been implemented. So I am speaking for
There you
those
go.
before me. Any other comments before we take a break? It's 10:40 a.m. now. Do we want to try me back in 10 minutes so that we start in 15 or?
Sounds great.
Okay, so shoot for 10:50, but we'll definitely try and get rolling as shortly thereafter as possible. Thank you.
Thank you.
Judge.
All right, well, why don't we go ahead and get started? We're back in session from the break and just continuing on with the extensive agenda. So Executive Director Bergstrom, you can go ahead.
Great. Thank you, Judge. And Ryan or Matt, could you let us know? I believe Representative Stevens and Professor Rago and Professor Mystic will be joining you at some point. So if they join, just let us know.
Will do.
Great, thank you. So let's turn to the next slide. And so we finished by talking about the changes since the last meeting to the matrix. And now what I'd like to discuss is really the effort underway, which is substantial, to do the reassignments of offense gravity scores. So we're moving from effectively a 15-point scale to a 42-point scale. And so what I'd like to do is just talk about what we've done since the last meeting, sort of review the rules of the road, and then we'll go into some examples. And there are 2 documents that may be helpful for this discussion. The first is a document that had just a bunch of example assignments, and that was provided, a week or 2 ago, and I guess a week ago, and it's in the meeting materials for tomorrow or for today. And it just is trying to sort of look at what the footprint for sentencing recommendations would be, and some specific assignments based on the process we're going to talk about. And the second document, which was just provided this morning and will be is generally available, but you might have just received it in your email in the last hour, is some details about those adjustments and enhancements. And so it's sort of a starting document or a draft for our discussion of that. So those are two documents. If you happen to have those, that would be helpful. I will try to do a screenshot along the way just to sort of point out some of those issues. So those are the two documents that might be helpful for the balance of this morning's session. So let's talk about the reworking of the offense gravity score. When we met last and when we started this process, we talked about two different approaches to doing OGS assignments. So the one approach is often called a prescriptive approach. It basically is a policy-driven approach, and it takes into account just the sort of the legacy of the guidelines and the decisions made by commissions over the years that led to the current assignment. And when you think about those kind of prescriptive approaches, it really does get to the issue of uniformity and proportionality. Like, what is the rank order of seriousness of offenses, and how is that reflected in the OGS assignments? And so, so that's an important consideration. The other aspect is what's called a descriptive approach, where we use sentencing data to help to guide the assignments. And we've talked about this before, about using median sentencing data as the basis of that. So this whole effort that we've been doing with OGS assignments sort of taps into both prescriptive and descriptive values in trying to advance the work we're doing. So let's talk about sort of what's changed since the last meeting. So our starting point, again, is the 15-point scale that we have, the current OGS categories. And at the last meeting, what our takeaway, staff's takeaway from the last meeting was, those current assignments should serve as a footprint. When you look at a current assignment and you look at the standard range for 0 prior record score, I think the takeaway was any new assignment should be within that footprint. So we should just figure out what part of the existing standard range should be used for the new assignment. And so that's sort of blending these two approaches. To some degree, we're taking the current guidelines, the sort of prescriptive guidelines, and using that to define the footprint. And then we're using data on median sentences to figure out what part of that footprint to use. And that goes to both the issue of what is the typical disposition? Is it probation or jail or prison? And then what is the typical duration? Because that will help us figure out where in the range to sort of plug in the new value. So under the current guidelines, the current OGS assignments, some of the factors that are already taken into account are the grade and the statutory max of the offense, the elements of the offense, and then other sentencing factors or enhancements that are used to subcategorize the offense. The other thing that's really visible with the current guidelines, the current OGS assignments, is the rank order, which takes into account proportionality. But over the years, there have continued to be adjustments to the OGS assignments. And that takes into account changes in policy, changes in legislation, things like JRI 2 and other stuff like that. But it also takes into account data, where if we were finding big departures from the guidelines, we'd bring that information to the commission, and the commission had an opportunity to adjust assignments. So, or if we had feedback from practitioners or from judges, we would bring that back to the commission, and maybe there'd be an adjustment the next time we did an amendment. So that's our starting point, the current OGS assignment. Next slide. So this is an example of how we would take that current footprint and then what our options are looking at the new OGS categories. And so this is just a cut and paste from the document that I sent, which included those example assignments. So let's look at the very top of the list. And at the top of the list, under the current guidelines, if you exclude murder 1 and murder 2, the current assignment in the guidelines is an OGS 14. And the current range of the guidelines is 72 months up to the statutory limit. Now, remember, the statutory limit is the longest minimum sentence possible. And that's because the guidelines are based on minimum term recommendations. So for an OGS 14, we'd expect sentence recommendations, or the standard range sentence recommendation starts at 72 months. But the statutory limit is either, or generally, is 120 months for typical felony 1 offenses, 240 months for many of the super felonies, and sometimes life. So that's a big expanse, 72 to life, or 72 to 240 months, or to 120 months. So those are the standards we have in place. And so the question is, what are the possibilities with the new guidelines? Well, here are the possible assignments, taking into account all of that territory that we have. Under the new guidelines, the top OGS assignment for things other than murder 1 and murder 2 would be an OGS 36. And the standard range would be 162 to 174 months. And you can see, sort of dropping down to the very bottom of the current standard of the proposed standard ranges would be OGS 30, which is 72 to 84 months. So if we start at the morning at the bottom, 72 to 84 months is consistent with the bottom of the current range, which starts at 72 months. But we have 2, 4, 6, we have 7 different categories from which to select assignments for an OGS 14 offense. So that's sort of the break there. Now, if you look over at the graphic on the right, there's sort of an illustration of this. So the footprint is 72 to statutory limit, and then we have the list from 36 down to 30 of the sentence recommendations, including the aggravated and mitigated ranges. And then I put that line in because that represents sort of the break between the new level that we created that focuses on super felonies, which is for values of OGS 33 to 36, and those other felony 1 offenses, or those other offenses that are OGS 14 offenses that are less than that, so 32 down to 30. So that's what we're working with. And so our task is to look at every OGS 14 offense and figure out which of these is the right assignment for that offense. That's the task. Next slide, Ron.
Mark, just so you know, Representative Stevens is now with us.
Oh, great. Good morning. So if we look at the other end of the scale, this is for offense gravity score 3. And for offense gravity score 3, the current recommendation is RS 3. So remember, RS includes probation and other restorative sanctions, and then 3 would represent 3 months of a minimum term of confinement. So if we look at the new categories we have, there are a ton of them for that one category. And OGS 3 could be OGS 10 under the new system, which is a confinement recommendation of 1 to 3 months. So that would be sort of the top part of the current range. And then if you think about all of the opportunities, all of the new categories for restorative sanctions, it includes at OGS 1, fines and community service. So number of hours of community service that can translate to fines, starting with 25 hours up to 50, 75. Then a transition to the use of probation. So this is level B, probation for 6 months, 12 months, 18, 24, 30, 36 months. And then ending with the OGS 10 of 1 to 3 months of confinement. So a lot to choose from. So, and it's illustrated on the left, on the right. The other thing to point out is, although the top gray shaded one is the one we're talking about, OGS 3, it sort of incorporates OGS 2 and OGS 1. There's no distinction. There's like an overlap. because OGS 1 is just RS and OGS 2 is also just RS. And then OGS 3 includes that plus some confinement. So, so the new approach is these discrete categories. The current approach is this sort of overlapping or lesser included categories, at least when you're at the bottom of the matrix. So that just hopefully just frames out sort of the decisions that we're trying to make. We're trying to look at what the current footprint is. We're looking at all of the options available under the new scenario, under the new proposed OGS categories. And then we're going to be using the sentencing data to try to figure out what's the best fit in terms of disposition and duration. Next slide, Ron. So the second step in the process then is sort of to define the rules of the road, because we need these in order to do assignments for over 2,000 offenses. So we need something to, just so that we know that we're being consistent. And so remember that we're looking at trying to come up with that standard range recommendation that's a single disposition and a sort of more directed duration. So we're using the typical sentence to determine the best fit. And we're looking at both the disposition and duration of median sentences to be that anchor. And this is just a recap from previous meetings, but we created a data set that has 3 years of data, 2017 through 2019. We did this because it was recent data. We used a lot of it so that we had bigger numbers, and it sort of averaged out sentences over 3 years, which is a positive thing. And it also avoided the problems with the 2020 data in terms of COVID impact. We used 0 prior record score. We removed inchoates and enhancements and mandatories so that these are clean cases, like our starting point. Keep in mind that inchoates and enhancements and mandatories will be sort of applied after the fact. Once we figure out the base assignment, then we can go in and we can adjust that with enhancements or with inchoates or an overlay of mandatories. So those factors aren't lost, they're just later in the process. And then the other thing is, that the information we used for the median was the most serious sanction for the most serious offense in the criminal incident. Because what we found over time was that when judges are imposing a sentence, the lead offense of an incident is really sort of the focal point. And so we wanted to use that in terms of the sentencing data we were focused on. Because in many jurisdictions, or a number of jurisdictions, lesser offenses might get guilt without further penalty, or there might be a concurrent sentence, but they're used as, to some degree, add-ons within an incident. But what's consistent around the Commonwealth is the sentence imposed on the lead offense in an incident is really the one that does serve as an anchor for the typical sentence in that case. And so that's why we're using that. We're using 0 prior record score, and we're stripping out things like inchoates, enhancements, and mandatories. So we've talked about this before, but I think it's a really solid approach to using our data to inform decisions about the OGS assignments. Next slide, Ron. Oh, I'm sorry. I see at least one hand.
Yeah, Judge Daly, go ahead.
Thank you, Judge. Mark, with the sentencing data, do you take it into consideration the geographic distinction of that data? Because I'm sure it varies a great deal from one part of the state to the other.
Yeah, Judge, good question. And in the past, and in fact, leading up to the last meeting we had when we did the initial assignments, we broke out the data to represent urban, suburban, and rural, but also, I think, for urban, Philadelphia versus other urban counties, so that we could look at that. And what we found was, in a lot of cases, they all lined up. They all sort of fit the same pattern. There was fairly good conformity to the guidelines, and there was not a substantial difference. But there were some areas where there was substantial differences. So I sort of recall like with drug offenses. Offenses in rural counties, especially for smaller amounts of drugs, were much higher than you found in either urban or Philadelphia sentences. So, rural counties were giving higher sentences for relatively small amounts of controlled substances. And at the other end of the spectrum, in Philadelphia, when there were more cases of really large quantities of drugs, and those just weren't found in many other jurisdictions. So it's just, Philadelphia has just a different profile in the cases that are going through the system or that are being prosecuted and sentenced with large quantities. And so there, the difference was that there just wasn't much to compare it to. So what we ended up, when you blend it all together, was at the lower end of the spectrum, there were more counties that probably gave a little bit more serious sentences because rural counties were sort of overrepresented. And at the higher level, those sentences were a bit lower, but they represented primarily activities in Philadelphia. So that's sort of how we looked at it to see if it made a difference, and we identified some areas where there were distinctions. But the real sort of bottom line was there was generally consistency, and there was, to the degree there was a difference, it might be on the margins of county jail versus state prison, like 11.5 versus 12 months. And maybe with certain offenses, more reliance on probation versus confinement for, like, at the lower end, like short jail sentences versus probation. So, there's those things, but in the end, we just went with the statewide median.
Okay, thank you.
Sure.
Thank you. And Judge Marsico, you have a question?
Yes, Mark, with regard to reworking the OGS assignments, you had a graphic up there a minute ago that showed like OGS of 3 and how that in the current guidelines would incorporate a lot of different things. What if the data shows for current OGS of 6, everyone's getting probation? Can we still rework that into, one of the ones that would be outside, like the categories that you had set up?
Yeah, absolutely. And that's why, I think we talked about this before, but it's a really good point. The commission decides all of this. So you can override any of this. You can give us, sort of at the last meeting, I think, our takeaway was that we initially were coming up with recommendations based on the median sentence and then trying to look at the current guidelines. And I think the commission suggested sort of flipping that. Let's start with the current guidelines, the footprint, and let's figure out how we use the data to figure out what part of the current guidelines to use. So that's why we sort of reworked this for this presentation. But, there's value judgments there. There's examples where there's, some pretty close calls in terms of whether it should be probation or jail, and also duration things. And there's a couple places where there's just a little bit of a mismatch between the current guidelines and the proposed guidelines because they don't quite line up. So these are really good opportunities for the commission to look at it and say, yeah, we think you got it wrong there, or we're just going to override this and do, we want to go with this versus that. So that's totally your call. We were just trying to come up with a system that we could generally apply to, over 2,000 assignments, and hope that the rules we came up with make sense. And then that you can review this and, and try to decide changes that you think are appropriate. I guess the other thing to mention is one of the benefits of taking things to public hearings, especially when they're sort of in the draft form, that we're just trying to solicit comment, is you have hundreds of other eyes looking at it. And people from different experiences are going to have different suggestions or recommendations. And it's sort of a way to leverage the public and practitioners to sort of look at cases and say, yeah, we think that assignment's wrong. And it's like not too late in the process for the commission to consider that and change it if the commission wants to. So I see this as, in like a first draft or maybe a third draft, but but that it's not a final draft. And so I'm going to go through 3 examples in a couple of minutes that just shows you specifically what we did. And then we're going to make available, we'll post over the lunch break, basically a list of maybe not all of the offenses, because that's a little overwhelming, but maybe most of the Crimes Code offenses, and maybe, A30 of the Drug Act, so that you have, an 80-page document, but you can sort of look through and sort of cherry pick assignments that you've had a lot of experience with or interest in, and see if it makes sense. And if not, we can throw that into the mix.
The follow-up question I have then is, with using a prior record score of 0 for our database, does that drive the numbers in a certain direction, as opposed if we looked at everybody that had a prior record score of 4 or an RFL? Did we run the data on that, or does this?
I guess let's start with 0 prior record score. 0 prior record score captures, depending on the year, but captures between 50 and 60% of all sentences reported. So it's a big chunk of what we see. And then the concern about like building in prior record score or looking at those kind of sentences is that it basically adds this factor that we're trying to come up with what's the right starting point for sentencing. So when we build in offenses with prior record score, it's a different question. So that may be helpful. I think it is helpful, and we've done this before, to just say, well, what does happen generally for a prior record score 4? What's the difference? And that's where we came up with this information on the impact of prior record score. At times, the recommendation is at times 10 times higher. And in practice, it is way higher, and it's also very disproportional. And so trying to sort of think about these issues separately, what should we do for our base assignment? What do we do about criminal history? Looking at those 2 things separately, and then you decide what the final decision is, and then we reconcile those and we run information about what is the impact in the sentence recommendations. Because we've talked a lot about really pulling back on the prior record score categories and recommendations, but we haven't talked as much about the adjustments that we're talking about or that we should be considering on the OGS side, where we actually use the baseline assignment and then adjust it upwards because there are factors that are in place, factors that maybe are about the like aggravating factors at sentencing right now, but also some of the things that get blended into the prior record score that we sort of take out of there and we use over an OGS. So maybe the examples will help, but happy to come back to this issue. And again, with Matt's discussion this afternoon on prior record score, that might have some insights.
Thank you. And then the hand's still up in the room. Is there an additional question, or just didn't put it down? Looks good. Any other question? Okay, go ahead.
Okay, thanks. Next slide, please. So here's an example of some of those offenses that were on that example case. So we'll start at the top, and this is again looking at the OGS 14 category, and I've split it into 2 tiers. So basically, what are some recommendations for those with statutory maxes of greater than 240 months, or statutory limits of greater than 120 months? So what are some suggested recommendations that sort of fit within the footprint, look at the data, but also take into account sort of the rank order that the commission has about the seriousness of these offenses. So this is both prescriptive and descriptive. So if you say the highest value in this band is an OGS 36, and instead of it being OGS 14 at 72 to statutory limit, this sort of takes some of the top part of that statutory towards that statutory limit of 162 to 174 months. Well, the highest ranked offense and a high reporting offense in terms of sentencing is rape and IDSI involving a victim less than 13 years of age, resulting in serious bodily injury. So in this sort of scaling, this recommendation, we would give that the highest value. The next category down, and maybe, I apologize, maybe I'll start at the bottom and move up because some of this will make a little bit more sense that way. At 33, we're trying to build in some of the values that sort of fit near the base of super felonies. So at 33, the standard range starts at 90 months, go to 102 months. And in there, we would include attempt, inchoate, so attempt, solicitation, conspiracy to murder, resulting in serious bodily injury, where the victim is less than 13 years of age. We'd also include as a comparable category, the inchoate murder, serious bodily injury of a law enforcement officer. We'd add to this category the assault of a law enforcement officer attempting bodily injury, discharging a firearm. And there's a mandatory minimum provision for that in section 9719.1. And then rape or IDSI involving a victim less than 13, but no serious bodily injury. The next step up would be the base assignment for murder 3, 114 to 126. If you remember when we looked at the distribution of data for murder 3, it was all over the map, but there were spikes in the data. There were sort of peaks in the data, and they were generally at 120 months, 180 months, and 240 months. So while there are lots of sentences less than 120 months in the data, including, I think, at least some probation sentences for murder 3, the sort of the base assignment that sort of fit was an OGS 34 that captures 120 months. So that's why that is the sort of the base recommendation for murder 3. Now, before I sort of move off that, remember what we talk about in terms of enhancements or adjustments. So one of the things I think we should be, that maybe you want to consider, and we can talk about this during enhancements, is that when we looked at and I think I provided you with like 10 example cases of murder 3 and sentences for them. What really was illustrated in those examples was the role of domestic violence, and really in two ways. We have a domestic violence enhancement. And for this murder 3, if murder 3 is related, if the aggressor has been involved in domestic violence, if it's against a family member, we would increase the OGS recommendation to 35 from 34. So it would increase because of that domestic violence provision. But one thing the commission may want to consider is, should there be an adjustment in the other direction if the defendant was actually the victim of domestic violence? Because in a number of the murder 3 cases we were looking at, and these were cases where the sentence was below 120 months, the defendant had been in a relationship that was an abusive relationship. And in the end, killed, this other person in the relationship. And it was, imperfect defense. It might have been a case of strategy where, they were trying for an acquittal or voluntary manslaughter wasn't one of the available charges for the jury to consider. Other things like that come into play. But again and again, we were seeing issues where the defendant was also the victim of domestic violence. And so the question would be whether that's something that the commission wants to think about as far as an adjustment in terms of that kind of victimization, not taking away the culpability of the person or the conviction, but recognizing it's a factor that might be a mitigating factor at sentencing. So that's an example of how the base assignment for murder 3 is what it is. but there are plenty of reasons for mitigation or departures below that we see, and trying to capture some of those to have a more sort of systematic approach to this might be worthwhile. Just like we say, you increase things because of specific enhancements. One other thing that I'd like to throw into this mix is we're talking about adjustments and enhancements. And this is specific to murder 3 because the increases are substantial just by one step. Right now, we have the deadly weapon enhancement policy that has an exclusion for offenses for which a deadly weapon is an element of crime. And so there's plenty of offenses that are excluded from the deadly weapon enhancement. But for murder 3 or for murder generally, or homicide generally, we don't exclude that. So we have a victim who is passed, and the question is whether the deadly weapon enhancement, given the recommendations we have for the offense of like murder 3, is the deadly weapon enhancement necessary or appropriate to apply? Because under our standard policy, the deadly weapon enhancement would be 1 point for possessed, 2 points for use. So moving murder 3 from what is a higher starting point than it is presently under the guidelines up to a 35 or 36 because a deadly weapon was possessed or used. The question is that necessary and appropriate? Because the real focus here is the death of the victim, and we capture that in the conviction for murder 3. So just like we exclude the deadly weapon enhancement when it's an element of the crime, it may be helpful to look at homicide or certain other offenses where you just exclude it from consideration because we've really addressed the issue that the deadly weapon enhancement is in place to address. So let me close out this by talking about if we start at murder 3 with the 34, then a step up in the assignments that take into account required enhancements or factors about culpability or harm or vulnerability of the victim, things like that, would be one step up. At 35 would be murder 3 involving a victim less than 13 years of age. Murder 3 of a law enforcement officer, or murder 3 where you're causing suicide. And the two that are highlighted or italicized and with the asterisks, those are two that we're required to do an enhancement for. So if murder 3 is the baseline at 34, the enhancement for murder 3 of a victim less than 13 is to step it up one step to a 35. The enhancement for murder 3 causing suicide is to step it up from the 34 to 35. So that's the framework we have for serious violent offenses. These are in some cases some substantial increases. It's within the footprint, but it's certainly increasing the baseline. And then the issue would be any adjustments or enhancements that could apply. So let me move to the next couple of slides and then we'll open it up for discussion.
Judge Bernstein, this is Ryan. I just wanted to let you and Mark know and everybody else that Professor Rago and Mystic have now joined us in the room.
Oh, great. Thank you. Welcome.
Thank you, Mr. Murray.
So that was the first tier of OGS 14. Here's the second tier. So here's the difference. For level F, if we look at level F, the first tier we said was 33 to 36, OGS 33 to 36, and it's limited to the super felonies, felony offenses with statutory maximum greater than 20 years. The second tier could apply to any offense, including a super felony. So it's just the use of sort of the bandwidth to spread out the recommendations to be more proportional and uniform. So the second tier would be from 30 to 32. And while the offenses may or may not be super felonies, the top tier would be limited to super felonies. So that's the distinction. So here's a couple of, here's a continuation of the assignments and a couple of questions. So for murder 1 and murder 2, as you know, there's mandatories in place that distinguish recommendations for individuals less than 18 years of age committing the crime. So we have those two categories, 15 to 17, less than 15 down to 10. And the question would be for murder 3, does it make sense for the commission to subcategorize murder 3 based on those age categories? And if 34, OGS 34 is the base assignment for murder 3, would it make sense to have reductions in the base assignment for murder 3 when committed by a younger offender? Now, if you think about the current OGS and the footprint starts at 72 months. And so the idea here would be to use that lower boundary of 72 months as the base assignment for murder 3 when the defendant was 10 to less than 15 years of age. And to use 2 steps up at 32 for murder 3 if the defendant was 15 to less than 18 years of age. So that's an example of, we don't have that in place right now. We treat all murder 3s alike at OGS 14. This is an opportunity to use this additional discretion to sort of spread out recommendations to provide proportionality and uniformity. And so that's a consideration for you to think about. This would link those completed murders, murder 3s, with inchoate murders, whether there's no serious bodily injury or there is serious bodily injury. So we've always said that inchoates, especially for felony 1s, are at least 1 step lower. And when we have big categories like this, it might relate to 2 steps. And this gets back to, I think, something Judge Marsico said, which is a really good point about like aggravated and mitigated ranges. Keep in mind, because we have more steps, more OGS categories, sometimes 1 step right now, like moving from an OGS 11 to an OGS 12, really represents 2 steps under the new guidelines because we sort of split the ranges in half. So 2 steps is sort of the equivalent to 1 step when we are up in the state sentence category. So just giving that for context. So the one question is about this, whether there would be support or interest in something like a subcategorization of murder 3 that takes into account the age of the defendant. The other thing is that you'll see on this cutout of what I sent you before, we provided a pretty comprehensive list of PWID recommendations and sort of built them into the matrix. And we did a couple of things that I wrote to you about, but I want to reiterate. One is that, we tried to realign the PWID categories sort of within the current footprint, and we might have to do some more work on that, finessing that. We also thought that it was really helpful to split out first offenses from second and subsequent offenses because of the doubling of the statutory max. And then the third thing that we talked about before and that we tried to put in place here is to think about whether we could have broader categories. Look, weight is not a great proxy for the recommendations we're coming up with, but it's sort of the tool that we have and that we've used traditionally over the years, and not just us. Other states, the federal government use weight categories for this. But one thing we could do, I think, under this new approach was do something closer to what we talked about before, sort of a low, medium, and high category where maybe we use weights, but we try to collapse some of these categories to just keep it a little simpler. And the other thing is, for the top category, figure out what the threshold for the top category is, and then use that, for more categories, because we have a lot of specific categories for large amounts of drugs, and we'll get a case or two a year out of that. And it just seems to me that if you come up with a high category, define it how you want, and then for those relatively few cases where there's, a major deal or a major quantity, let the court aggravate, let the court depart above the guidelines, because it's not a typical sentence. And this is all about typical sentences. So let's figure out what the threshold is for a high category. And let's just give that category an assignment. And we can distinguish between first offenses and subsequent offenses, but it moves to just a simplification. And many of you know, a lot of these drug offenses, especially at these high categories, and especially with criminal enterprises, can be transferred over to the federal side. So there's just a lot of reasons to try to think about this and simplify it. And here's one of the recommendations we have in this level, and that is that the top category of drugs that we'd identify would be PWID for fentanyl when it's 50 grams or more. And this would be a second or subsequent conviction. So a max of 360 months rather than a max of 180 months. So that's just a consideration for that additional category that we've created. So I think at this point, before I go into specific examples, maybe I'll turn it to the judge in case there's any questions or comments.
I don't see any hands up. Any questions or comments? And Mark, if we have any thoughts on other ideas for aggravating, mitigating, or step up, step down, I think, are we going to address that at a different time?
Yes, we are. And really happy to gather those and try to plug them in. But I'll give you a starting point. Really happy to hear that, though.
Okay. And yes, just remind me that I have some ideas, but I won't hit them now. And then Representative, I'll forget. Representative Krajewski, you have your hand up. Go ahead, please.
Yes. Thank you, Chair. Mark, I just had a clarifying question in regards to something you mentioned with the murder 3 categories and the deadly weapon enhancement. So just so I understand it correctly, the point that you were making is in instances where basically like the use of a deadly weapon is already kind of reflected in the base charge, is it necessary to then add the deadly weapon enhancement? Like, for example, if we already know based on the charge that a deadly weapon was used, is it redundant to add that extra enhancement? Is that the line of reasoning?
Yes, that's exactly it. And it really gets to, under the current policy, it's really based on elements. Was deadly weapon an element of the offense? Well, for murder 3, it's not an element of the offense, but the consequence of murder 3 is that you have a victim who's dead. And that's really sort of the focal point of the deadly weapon enhancement, about discouraging that. And we've substantially increased the recommendation for murder 3, sort of the starting point. And so it seems, you could argue we've captured the enhancement, if it was there in place before, into what we assume as an assignment for murder 3. So yeah, I think that's exactly the point. Thanks.
Okay, great. Thank you. That's all I have.
Thank you, Representative. Any other questions? Okay, then we can go ahead.
Great, thanks. Next slide, Brian. So I'm going to go quickly through 3 examples, and we've sort of talked about these before, and this is just a streamlining of the stuff and sort of a focal point on the OGS assignments. So the first one we've talked about is felony 2 burglary. So burglary, not a house, no person present. Under the current guidelines, this is an F2, so the statutory max is 10 years. So the statutory limit, the longest minimum sentence, is 5 years or 60 months. Is an OGS 5. So at a 0 prior record score, that range is RS to 9. Under the current guidelines, if the court was going to impose, it was going to use restorative sanctions, we recommend probation for 2 years. If the court's going to use other restorative sanctions, we recommend a term of community service of 225 to 250 hours. Or the comparable, the equivalent in fines. Next slide, please. So here's the distribution based on 497 offenses where 0 prior record score, most serious offenses, felony 2 burglary, no enhancements, no inchoates, no mandatory. So this is the clean 0 prior record score, felony 2 burglary. And this is the distribution of sentences we've seen based on the RS to 9. Next slide. And so there is the current footprint. It starts at RS, So it means guilt without further penalty and any other kind of community-based sanction, up to 9 months as a minimum term of confinement. And you'll see that there's 3 spikes in the data. One of the spikes is at probation for 36 months. Second spike is at 6 months of confinement. Third spike at 9 months of confinement. But you line all of these up from start to finish, the midpoint, the median sentence is 3.5 months of confinement. Next slide. So if we think about the current guidelines, if we're starting with RS-9 and we're figuring out where does this fit in, the best match for this for a 3.5 month minimum sentence of confinement is an OGS 11, which provides for a minimum range of 2 to 4 months. So 3.5 months fits within that. So instead of having RS-9 as the range, where we provide anything in the community up to 9 months of minimum confinement, we instead focus on a specific disposition, which would be confinement in a county jail, and a specific duration, which is 2 to 4 months, which sort of captures the current median sentence for this kind of offense. So we improve the consistency and the confidence people have in that type of sentence recommendation, reflecting what's happening right now. Next slide. We'll move to a second example, and this is the first of 2 drug examples. So PWID, this is marijuana, less than 1 pound. The current guidelines, OGS 3, ranges RS to 1, probation 1 year, community service 50 to 75 hours. The statutory limit for a first-time offense is 30 months. The statutory limit for a second or subsequent offense is 60 months. Next slide. So Matt had provided this in previous meetings, sort of a distribution of sentences for certain drugs offenses, marijuana and cocaine. And I've sort of repurposed it to sort of just point out some of the data we had on marijuana less than 1 pound. So the first takeaway is the most prominent sentence was probation. And the average, or the median, the median sentence for the probation was 36 months. Next slide. But keep in mind, the recommended range was RS to 9, right? Or whatever it was, RS to something. And there were 30% of the cases that were confinement cases, county jails cases, basically. So while the sort of the leading sentence recommendation, the median, was probation for 36 months, confinement is part of the mix. So next slide. So one consideration is, what about splitting this? What about having a recommendation that focuses on a first-time offense for marijuana less than 1 pound, based on what we see as some of the data driving that? And then let's have a second recommendation for second or subsequent offenses. So one possibility is to have an assignment for that addresses that probation sentence. And you could argue that the assignment you could use is probation for 36 months, which would be an OGS 9. But that takes into account, or these sentence recommendations take into account that we're going to have a second recommendation. We're going to give you a second recommendation for second or subsequent. And some of the current sentencing information, the current use of probation for 36 months, could be for second and subsequent convictions for higher statutory max. So I think there could be an argument that if you're going to separate out just first-time offenders for PWID less than 1 pound of marijuana, it might make sense to drop down the recommendation on probation to 2 years, to 24 months, because then with adjustments, you can go up and down from there, but you stay within the probation band, which is sort of the focus. Whereas if you're at a 9, any kind of adjustment up would put you in county jail. And while that might be appropriate as an aggravated sentence or a departure, as far as just structuring this whole thing, it seems if you're creating 2 categories, that providing a clearly probation sentence for that lower category of first time makes sense. So that's where the recommendation is 24 months of probation, recognizing it's a 30-month statutory limit, 60-month, 5-year statutory max. Next slide. For second and subsequent offenses, the statutory max increases, it doubles, as does the limit. So the limit is now 60 months, 5 years as the longest minimum sentence. And because confinement represented about 30% of the cases, the idea of looking at the median confinement that you have and trying to capture that, trying to use confinement as a sentence recommendation, this would bump up to the idea of using 1 month of confinement. So OGS 10 is 1 to 3 months of confinement. This takes into account our current footprint, right? The footprint is RS1, and so 1 month of confinement would be the lowest level of county confinement in OGS 10. So that's an example of how we use the data to sort of inform what part of the footprint to fit in. And then we build in this concept of second and subsequent offenses for drug offenses because they are back in the system. Now, this is one of those things where it's sort of, I guess, not as clear, but we do want to make this clear. One of the concerns about the prior record score, or one of the identified uses or purposes for prior record score, is this idea of holding someone accountable for coming back into the system. This is one way of moving some of that consideration from the prior record score to the offense gravity score assignment. That we're saying, because this is a repeat offending, a sort of pattern behavior, there is a price to pay for that. There's a retributive price. There's a different assignment that comes into play. And it reflects what the General Assembly has done in terms of enacting a higher statutory max for that. So creating two categories with the second or subsequent up a level is one way of getting at that. It doesn't mean that we remove that from the prior record score, but it's that we've reflected in the offense gravity score. So there is, so it's not like all or none. This is a blended kind of approach. Let's go to the next example. So this is the third example, the second PWID example, and this deals with cocaine. So 10 to less than 50 grams. The current OGS assignment is 9 to 16 months for 0 prior record score. Statutory limit, first offense is 60 months, second or subsequent offense is 120 months. And here's that distribution at the bottom. And we're in that category. Remember, when we were preparing information for you before, we were splitting out the categories so that you could see if there's any distinctions regarding quantity of drugs. And what we found was the category we had of 10 to less than 50 grams, really the profile was the same for both of those. So we really, collapsing them made sense. So a 10 to less than 50 gram category makes sense. And you can see there that the median sentence was confinement. And in these cases, it was confinement in a county jail of less than 12 months. And confinement was right around, between 69 and 77%. So there were still, 25% of the cases were probation cases, but this was the confinement median that we saw. Next slide. So again, looking at that and thinking about splitting this out into first offense versus subsequent offense, for the preliminary assignment for a first offense, the idea here was to take into account a county jail sentence. So sort of focus on that median sentence and that it was less than 12 months, so it was a county jail. And instead of making it confinement in county jail or state prison, we say a first-time offense, the target is county jail. So we go with an 18 where the minimum sentence caps at less than 12 months to keep it in a county jail. And then next slide, when we move to a second or subsequent offense, we bump it up 1 because then that provides for a state sentence recommendation, exclusively state sentence, for 12 to 18 months, which fits in the general bandwidth that we had, the footprint we had. So we capture the 9 to less than 12 at the lower end of the current range, and we capture the with the 12 to 16, we capture the upper end of the current range, which goes up to 18 months. So those are examples of how we would do assignments, or how we did do assignments across the board. We didn't go into quite this much detail on each, and we probably don't have the time for me to go through the same analysis for over 2,000 cases, but I hope that at least gives you sort of a sense of the approach we took and whether we're on track with what we've done. Let me just hit a couple more slides, and then we'll close with just any kind of questions you have. So we've talked a lot about enhancements and adjustments, and enhancements, and here are just the general rules, and then I'll mention some documents that we can look at. So on the enhancements, these are mainly statutory enhancements. We're required to provide these enhancements, but some have been sort of done under our general authority to write guidelines. So the general enhancements that we have in place that apply to any offenses coming before the court include things like the deadly weapon enhancement or the domestic violence enhancement. And the idea here is for those kind of general enhancements, you get a conviction offense, you figure out what the OGS assignment is for that offense, and then if this factor is present, you adjust that based on the enhancement steps. So if the deadly weapon enhancement is 2 steps for possessed and 3 steps for used, unless that's an element of the crime, you'd start with the base assignment, you'd add 2 or 3 steps, and that would tell you what the assignment is, what the recommendation is for that offense. So that's the adjustment related to enhancements. But there are other enhancements that are offense specific. The example I showed was murder 3, where the victim's less than 13. So we have a requirement to enhance our sentence recommendation. Well, as I said, if our baseline recommendation for murder 3 is OGS 34, the enhancement in this case would be 1 step up. But instead of saying to the user, murder 3, you figure, there's 1 step increase, what we can do is just subcategorize this. We can say, we know that is in place, we'll just add that to the guidelines. So when you're looking at the guidelines, you'll see options for murder 3. One of the options is murder 3, victim less than 13, and you'll just see the assignment is OGS 35 instead of OGS 34. So that's an example. Child pornography is another one, but it's incredibly complicated because there's 5 factors or whatever that we have to look at and build into the guidelines. And some of these in the past we subcategorized, and some of these we said to the court, if this is present, add this much time or do this other stuff. So what we tried to do was just try to mix it up and try to rebuild that enhancement so it gives approximately the same penalty recommendation as under the current enhancement, but it sort of builds it into the guidelines so it can be automated. So I can later go through an example of that, but enough to say that the whole effort here for enhancements is to build them in. So through SGS Web, it's an automated process. And even for end users, it's a fairly intuitive and easy to calculate or determine enhancement. Not a lot of math involved and not a lot of charts and things to look at. It's all sort of built into the process. So we can talk more about that later, but subcategorization or step increases are the way that we will be doing enhancements if this goes through. And I think that will streamline, simplify, and standardize a lot of what we're doing with enhancements. The second added category is then adjustments. These are taking factors that often are viewed as aggravating or mitigating factors, looking for common ones, and then applying a given value to those. 1 step, 2 steps, 3 steps, increase or decrease. And you're going to find that examples of increases could be that temporal or offense pattern, where you say, okay, here's a burglary, here's the base assignment for burglary, but there was a string of burglaries, or this person has a history of burglaries. That is an adjustment up. that's a temporal or offense pattern. So we increase the OGS assignment for that burglary because it's part of a pattern or an offense pattern or a temporal pattern. Another example is repeat victimization. And that concept of victimization could be expanded to talk about vulnerable victims, other things like that, multiple victims in an incident. But the idea that victimization is a key consideration, both in the guidelines and from sort of the retributive purpose. And so in the OGS assignment, we look at the base assignment, and then we figure out if those factors are present, and that would increase the OGS. So we are, we've talked about the prior record score being reduced, but there are aspects of retribution and even risk that we're building into the offense gravity score in a very different way than we do right now. So that can't be lost in looking at this holistically. In adjustments, there are also adjustments down. And during our going back to the strategic planning work group, this was something that was supported by all the parties there in terms of it makes sense that everyone knows that there are factors that can be used to mitigate sentences, and they're standardized and they are part of the process. It's not ad hoc. It's not in this county you get it, in that county you don't, or with this judge you get it, in that it's built into the guidelines as an adjustment down. So some of the things we've talked about in the past was acceptance of responsibility and substantial assistance. I mentioned that there could be discussion of things like if the defendant is actually a victim of domestic violence, ongoing violence, should there be a consideration of that? There's other factors, as the judge said, we can talk about a lot of these factors, whether they're aggravating or mitigating factors, or we build in adjustments. But public trust, abuse of trust has been often used as an aggravating or mitigating reason. Drug dependency has often been used as an aggravating or mitigating reason. So there are a number of those kind of issues that we can discuss, but this is just to give you sort of the framework. And let me just finish by mentioning a couple of things that we found in looking at the U.S. sentencing guidelines, because during our last meeting, we talked about, well, are there other examples that we should consider? Well, I think the one that really stood out in reviewing the federal sentencing guidelines was role in the offense. We do not include that in the guidelines now, and it seems to be something worth considering, and it would actually operate in both directions. So under the federal sentencing guidelines, one of the considerations is does the person have in effect an aggravated role in the offense? The leader of the offense, the scheme, or the kingpin, whatever else. And then the other option is, does the person have a mitigated role? Just the lookout or something like that. So the idea of, if something like that applies, it's the neutral too. You're in the offense, but if there's a way of capturing role in the offense, that may be worth considering as an adjustment in this process. So we'll talk more about that later, but I wanted to sort of get through that explanation. And let me mention, I guess, the final thing. And next slide, please, Ryan. There are two handouts that I mentioned at the start. We're sort of out of time to discuss at this point, but we can capture this afternoon at some point if it's helpful. One is that list of OGS assignments, example OGS assignments. And I'd encourage you to take a look at that list and those assignments. And if there's some that just don't make sense, or you think are one-off or whatever, that might be a good way to have a discussion about the rules of the road and how we apply it, or if we're on the right track. Because we've also produced a similar kind of document, not all that detailed, but basically an updated list of all OGS, all offenses. That's 80 or 100 pages that has default assignments for all of these based on those rules. So we can we can look at anything you want to look at, but we have to figure out how we manage the time to do that. And then the second document that was provided this morning is a document that outlines the adjustments and enhancements. And again, this gets to Judge Bernstein's point about there may be other factors that we want to consider and build in. There may be some we want to take off the list, but that's like a starting point where you see all the enhancements and how we sort of redrafted the enhancements. But I think equally importantly, there's three categories that I think I draw attention to. With the adjustments, the first category is that there are offense adjustments. So one of the things we've had in the guidelines for many years is a reduction for an inchoate offense. If you have an attempt, solicitation, or conspiracy to a felony 1 offense, the OGS for an inchoate is 1 step lower than the object offense. One thing to consider is whether that policy, well, we retain that policy. One thing to consider is whether we extend that to all inchoates, because remember, we have a lot more granular guidelines now. So the difference between a completed offense and an inchoate may be useful to articulate in the guidelines as effectively 1 step down. So whether we expand that to all offenses or retain it at just an F1, something for consideration. Another example in that course adjustment or offense adjustment is ethnic intimidation. Works in the opposite direction. It's always 1 step up. So that's built into the guidelines. But because we split out the guidelines, it would be a 2-step increase instead of a 1-step increase. And then the same kind of thing applies to terrorism and eco-terrorism. They're all linked to an object offense. And so whatever we have for the assignment for the object offense, it's adjusted up to take into account those other circumstances. So that's the one category that I mentioned. The second category that we just discussed was the sentencing factor adjustment, things like cooperation or course of conduct or role in the offense. And then the two enhancement categories that are outlined in the document. One is the general enhancement provisions like deadly weapon in school and youth, criminal gang and domestic violence. And the other one is all of the offense specific assignments, child pornography, 3rd-degree murder, victim less than 13, and many, many others. So it's a pretty long document, but it's sort of the details of all the stuff we talked about. And so with that, we can talk about those documents this afternoon, later in the day towards the close of the day, but I wanted to give you that overview to get started. And if you need something to look at over lunch, those 2 documents would be a great start. With that, I'll turn it back to the judge, and I know we're about to wrap up and go to lunch.
All right, is there anything anybody else wants to add or any other questions before we step away for the lunch break? I'm not seeing any. And then Executive Director Bergstrom, are we going to reconvene at 1 p.m.?
I think that's the plan. So here's the story. Apparently for everyone in Harrisburg, you get a free lunch, so enjoy that. Also, there were some requests, since you're in the Capitol complex, of building in a brief tour of the Supreme Court courtroom. And we've had contact with personnel there, and a tour is available. I think Jadine will shepherd you through the process. I think we were trying to target 12:30 for the tour, but Jadine can give you information there if you want to go on that tour and enjoy your lunch. And we can plan to start at 1 o'clock unless we hear from Matt that there's delays there, and then we can push it back to 1:15 or 1:30.
Anybody have any thoughts in terms of pushing it to 1:30? Pin drop.
I guess, we can check in at 1 and see what the status is.
That's what I think.
And then if we need to delay, we get bonus time.
Okay, who's going to be directing that? Because they're welcome to text me and kind of keep me apprised of where you are.
I think Matt's our man on the scene. So
okay,
I'd say Matt can do that.
Okay, so Matt, if you don't have my number, Mr. Myers has it, he can provide it to you. I'll plan on, we'll check in at 1. And for those of us who are not privy to the tour, if the tourees indicate that they're still out and about, after that check-in, we'll just give a confirmed time. So everybody plan to meet back at 1 p.m. And from that point, we'll have a better idea if we're starting then or a start time. And if anybody needs me for any input during the break, you're always welcome to text, okay? Or email. Thank you.
Great, thank you.
So then with that, we're adjourned. We're not recording it. Hi, we're back for the afternoon policy meeting. I'm going to just turn it back over to the executive director to keep going forward.
Thank you, Judge, and good afternoon, everyone. The afternoon session is going to start with a party discussion of prior record score. We talked about it a bit in the morning and certainly over the last year or so. And so Matt has taken the lead on this. He will provide a lot of information about the prior record score, link it to that revised matrix we talked about, and then talk about some example cases where you can see everything sort of in action. So I think that will be really helpful for just a discussion of this and a better feel for how everything works together. And we'll take as much time as necessary for that. And then we'll work up until 4 o'clock. So we have other things we can discuss in terms of general sentence recommendations, some of the procedural things in terms of redrafting the text of the guidelines. So don't worry, we'll fill the time between now and 4 o'clock. But with that, let me turn it over to Matt to take the lead on this discussion.
Thanks, Mark. Earlier this morning, a lot of time was focused on the OGS axes of the general or basic matrix, and now we're going to focus again on the prior record score axes of the proposed 8th edition guidelines. And most of this material you've seen in some shape or form, but I think it's worth going back through to see what the individual components are of the prior record score and how it's calculated and how it's implemented will be part of our conversation later. In response to some requests previously, Mark prepared a short memo that goes through a step-based process of how we would calculate the prior record score, and a complementary effort that myself and some of the folks in the research and data analysis unit worked on was what a scoring sheet might look like for paper and pencil. And what I'm hoping is that between those two documents, and I'll work through them in this presentation, you can get a flavor or an understanding of how these different decision rules come together to determine what the prior record score is. And then, as Mark said, later in this presentation, we'll look at basically the intersection of prior record score and OGS and look at the sentencing recommendations, not just for PRS equals 0 or none, but as we move across the PRS levels for different OGS assignments. And we're going to make a direct comparison of using the 7th edition guidelines for some scenarios and see what the recommended standard range is for the 7th edition guidelines, and then using the new OGS and the new PRS, see what the standard range recommendations are on the proposed guidelines, and hopefully have some discussion about that. But this first presentation here is really focusing on prior record score. And I would like the commission members to be considering some issues related to implementation. I know that at the last meeting, we talked briefly about this idea of crime-free period for lapsing and what does a crime-free period look like, and some of the logistical concerns with determining whether or not it's crime-free. So as I go through this, probably in about a half hour or so, we can really focus in on that discussion, since for both juvenile and adult lapsing considerations in the 8th edition proposed guidelines, there are features where there is a crime-free lapsing period. And you'll we refer to that as a gap period. We'll talk about the difference between DK and gap lapsing policies and maybe consider the possibility of moving towards a decay policy for all offenses, both juvenile and adult. If that's something feasible or practical, we can return to that. Okay, so as we know, the current prior record score is calculated by using points. There are certain offense point values assigned to prior convictions or prior adjudications. As Mark mentioned, it's quite complicated of how they're counted and how they're arrayed and how they're scored. And as we've shown in prior meetings, there's lots of different ways to get 3 prior record score points, 4 prior record score points, 5 prior record score points, and maybe the combinations that lead to those prior record score points are in fact not commensurate or proportional to one another. So in this revised approach, we're moving from this point-based system to a categorical system. And just as a reminder, and again, we've talked about this previously, this is not necessarily any new material here, is moving from 8 categories. Currently, we have 0 to 5, and then our RFL and REVOC categories to 4. But our high category, as Mark noted, does include RFL and REVOC in its categories. So we'll have none, low, medium, and high. And those will be based upon the highest statutory grade of prior convictions and adjudications or adjudications, and then the number of those priors. So we're looking at single versus multiple priors. And then we'll be seeing later if it's from the same or a different chapter, the impact that may have for those priors. This proposal extends the criteria of lapsing for juvenile adjudications. Currently, it looks at a crime-free period between 18 to 28 for lapsing of all offenses except for 4-point crimes of violent offenses for juvenile adjudications. We're going to be looking at it through a slightly different lens and also accommodating for those crimes of violence priors for juvenile adjudication. Currently, there is no lapsing provision for adult offenders, so we'll be introducing this crime-free period, at least for certain types of offenses for adult offenders. And it's just worth reemphasizing what Mark mentioned, that in practice, coming out of the recommendations of the academic review panel and some other discussions, that OGS is considered the primary driver of the sentencing recommendation, and that we really are looking at reducing the impact of the prior record score, and where possible, also trying to reduce any sort of racial and ethnic disparities that may exist within the prior record score category. This is just the first schematic of how to think about the prior record score. And as I mentioned, we'll walk through the steps that Mark provided in a memo, and then an alternative way to think about scoring this. So this will be reinforced through this presentation. But currently, the 8th edition proposed guidelines has a prior record score of none. As we know now, under the current system, PRS 0 actually is not a true 0. You could have a misdemeanor offense, one that is not actually scored and would keep you in the 0 category. So we now have adopted a true 0 that we're calling our none. The low category is made up where the most serious prior conviction or adjudication is a misdemeanor 3, a misdemeanor 2, or an ungraded misdemeanor. And that could be a single or a multiple incident offense would lead you into the low category. And then a single incident, when your most serious prior is a misdemeanor 1, we would count that in low. When you have multiple instances of that misdemeanor 1, you would move to medium under our medium B category. So as I started with, it's determining the most serious statutory grade offense and then seeing how many of those there are of that same grade. So that back to the medium, we have felony 3s, felony 2s, felony 1s, and unclassified felonies as falling in the medium category, and then multiple incidents for misdemeanor 1, felony 3, and unclassified felonies. And I just want to say something briefly about the unclassified felonies. This especially relates to our drug priors. And we thought about how to assign them a specific classification here. We thought one approach was to assign them or make them commensurate with felony 3s. And this is consistent with the current prior record score, where the drug felonies are not counted towards RFEL or REVOC. So in essence, they operate similar to the felony 3s, whereas you need to be a felony 1 or felony 2. So we're not counting those unclassified felonies. And our other consideration here was that this may be a way to mitigate some of the racial disparity on prior record score, again, by keeping this in the middle category rather than for drug offenses being moved up towards the higher category, RFEL or REVOC, under the new schema. And then on the high, we have our multiple incidents of felony 2 or felony 1. If they're not crimes of violence, then they would be in our RFEL. If they are crimes of violence, felony 1 or felony 2, then you fall in our REVOC category. It's also worth just highlighting that juvenile adjudications for misdemeanor 3 and misdemeanor 2 are not included in the determination of prior record under this proposal, which is consistent with the 7th edition counting guidelines currently. So as I mentioned, on November 23rd, Mark distributed, as part of his Thanksgiving break, reading materials, this draft prior record score policy memo. So I'm just going to walk through some of the language that was used and some of the considerations for how we're thinking about counting prior adjudications and prior convictions that lead us up to determining what that prior record score is. So essentially, these are our counting rules for how we would go about assessing prior convictions and prior adjudications. So in step 1, Mark outlined that we would identify all prior adjudications and convictions by referencing rap sheets or court records, and identify offenses for which the defendant was adjudicated delinquent or convicted prior to the date of the current offense. When we focus on the adjudicated delinquent component here, we would look at the most serious offense for which the individual was adjudicated delinquent from each juvenile court disposition that meets the following criteria. Individuals 14 years of age or older at the time of the offense, and then there's an express finding was found by the juvenile court that the adjudication was for a felony or misdemeanor 1 offense. Again, we'd be excluding misdemeanor 2s, misdemeanor 1s, and unclassified misdemeanor offenses from this count. I'm sorry, misdemeanor 2s, misdemeanor 3s, and unclassified misdemeanor offenses. What you see here is consistent with current practice of the 7th edition guidelines. When we're thinking about adult convictions, again, we would look at rap sheets or court records, looking at all for adult convictions, every offense for which the individual was convicted, whether or not a sentence has been imposed. So for former Pennsylvania offenses and out-of-state offenses, we would determine the current equivalent Pennsylvania offense and identify the grade associated with the current equivalent offense. So this, again, provides us with a little bit more efficiency here in terms of these out-of-state convictions or priors, where we could assign it or think about what the equivalent grade of that offense would be, and utilize this framework to accommodate for that. And for both of these, the feeling is that the burden of proof is on the prosecution for determining adjudications or convictions included in the prior record score. So now I want to move on to thinking a little bit about, now we've identified offenses that may be counted in the prior record score based on prior convictions and prior adjudications. looking at the offense grade. And now we need to take into account if any of those should be eliminated from the calculation. And this is where this idea of lapsing comes in. And for purposes of this meeting, I relied on a publication from the Rabina Institute at the University of Minnesota. They have a handbook called the Criminal History Enhancement Source Book. And they distinguish between two types of lapsing criteria, decay and this idea of gap. And decay is where prior convictions or adjudications age out of the criminal history calculation once a defined period passes. The conviction or adjudication is then no longer counted, regardless whether the offender has remained crime-free. So one example of this might be our 10-year DUI look-back period that we currently have as an example of that those prior convictions are no longer considered for the current conviction if they go past that 10-year look-back period. So we'll see examples in our current recommendations for juvenile adjudications where we're relying on a decay policy, where we're saying when the offender reaches a certain age, certain types of prior adjudications may no longer be considered. The other type of lapsing policy that we're considering are these gap policies. And this requires the offender to achieve a crime-free existence for a defined period of time. So remaining crime-free, for example, in the juvenile adjudication between 18 and 28, or crime-free from 10 years from your current offense. And we'll talk about a number of different iterations of those for different types of offenses for the adult lapsing considerations, as well as for crimes of violence for juvenile adjudications. So our preliminary or our starting point where we're thinking about for these lapsing criteria is, again, following in Mark's memo for a lapsing procedure in this step 2 is to remove all offenses with the following grades. So for juvenile adjudications, when the individual reaches 21 years of age, misdemeanor 1s, felony 3s, and felonies are no longer considered. At 25 years of age, felony 2 and felony 1, unless specified as crimes of violence, are no longer considered. And then there's a 10-year crime-free period at any point if the defendant remains crime-free since the last adjudication or conviction, then all juvenile adjudications, including those crime-free instances, are removed. So this is something we'll return to at the end of the presentation to be thinking about comments or considerations on those gap and the lapsing policies that are provided here or the gap and decay policies that are provided here for juvenile adjudications. And I'll run through another set of examples that showcase these particular decisions and make sure that we understand how they work in practice for certain different types of offenses. And something also to consider as we mentioned this, or Mark mentioned this at our last meeting, is how will we go about defining what crimes of violence are for juvenile adjudications? And there's 2 potential definitions that could be considered, and there's probably others. One is from 6302, thinking about the exclusions from the Delinquent Act. When it's defined what a delinquent act is, there are certain offenses that are listed that suggest that it's no longer a delinquent act. And that is a smaller subset of offenses than what is listed in the 3-strike offenses, or what we typically think of our 4-point or crimes of violence offenses in the statute. So we certainly can consider that or discuss that. Certainly, we also could disseminate those lists of what those offenses are and what's included in each of those listings. For adult convictions, as I mentioned, the adult convictions all follow these gap policies. And for the defendant who successfully completed a crime-free period since the last conviction, we would remove misdemeanor 3s, misdemeanor 2s, misdemeanor 1s, our unclassified misdemeanors, our felony 3s, and our unclassified felonies. We then had a 15-year crime-free period for felony 2 or felony 1 offenses that are not crimes of violence, and then a 25-year crime-free period for those crimes of violence. And in this case, the burden of proof is on the defense for determining the lapsing of any priors. And when we get to the discussion about implementation, we can think about scenarios where, for example, there's a probation violation and the individual is placed back in confinement for a period. Does the clock stop? Does the clock get reset? Does the clock turn on and off? So there's a lot of considerations for what this notion of crime-free would be. And one possibility, for example, is just throw this out as something to ponder. So if we looked at A as an example, and we'll get to this in a little bit, but so rather than saying completed a 10-year crime-free period, what if all those offenses are no longer counted in the prior record score after 15 years? So we change from a gap policy to a decay policy for adults. Is there something that would be commensurate with these values in essence, but allowing for additional crimes during that period, but in essence, those become stale prior record scores after some duration for these types of offenses. So our starting point, though, is this set of lapsing criteria that has been defined previously. All right, so as I mentioned, staff was working on just another way, and we wrestled with like a paper and pencil version. We're, of course, envisioning this being automated, but was there a way for us to express in a flow chart or some sort of decision rules of how you would go about determining prior record score? So if we're relying on the most serious statutory grade of the prior conviction or adjudication, we would start in essence and ask, was there a prior crime of violence, felony 2 or felony 1? If the answer is yes, we start in that top left box. If the answer is no, we then move to the next box, which is, was there a non-crime of violence prior felony or adjudication that has not lapsed, that's a felony 2 or a felony 1? And then if no, then we move to the next one, which is C, which would be our felony 3 or our unclassified felonies. And we'd move on from there sort of in a decision tree. And then within each box, we would then look at the number of adjudications and the number of adult convictions that haven't lapsed, add them together and see how this comes together to create the recommendation for the prior record score. So for example, an individual has 2 prior misdemeanor 2 adult convictions. And this individual was not crime-free for 10 years. So those 2 misdemeanor 2s would count towards the prior record score. So we would go down to and this again, we probably won't use this schema, but if you're thinking of this flow chart, we would find the box with the decision rules for misdemeanor 2s. And we'd say number of prior convictions is 2. If it had been crime-free, we would have removed 1 or both of those, depending on where those priors occurred. And then we use our reference to see that for that combination of adult convictions for misdemeanor 2, that the prior record score for this individual would be low. And remembering that the rule for misdemeanor 2s is that you could have 1 or multiple prior convictions and you would still receive low. So maybe not the greatest example for how this sheet works, but you get the idea of just again, a flow chart of decisions of determining this by starting with the most serious grade adjudication and conviction, determining whether or not that conviction or adjudication lapses, and then working your way. Finally, on the bottom right is a situation where there's none. And of course, then the prior record score would be none. So we'll use this framework later to look at a few scenarios when we're looking at the intersection of OGS and prior record score, to be thinking about what the prior record score is, just to reinforce some of those decision rules. So at our last meeting, I went through 7 or 10 roughly examples using this timeline. And the purposes here, the beginning set are just to reinforce what the scoring rules are, especially as they relate to lapsing, and then a couple illustrations of how the prior record score work in practice, especially when the prior convictions or adjudications are from the same chapter. As Mark mentioned earlier, and we talked about at our prior meeting, we would essentially have two movements for that. We would have an increase potentially in the prior record score, and we'd have an increase in the OGS for a second or subsequent offense, a step up on our OGS categories. So it has an impact on both dimensions. However, if those were to lapse, it's possible that those priors do not impact the prior record score, but would be considered in the OGS scale for a second or subsequent offense, even if it lapsed for consideration for prior record. Okay, I just realized I just spoke a lot, probably pretty fast. So let me just take a quick break, turn it to the Judge Bernstein, and see if there are any questions or comments before I forge ahead.
All right, thank you. I'm looking to see if there's any hands raised. I don't see any. Okay, I think that you are stuck forging ahead.
Excellent. All right, in this illustration here, we have a current offense, which is occurring essentially at the current time. And then there's just a period of prior time that extends beyond 20 years that for our purposes, of course, for prior record score, all the offenses in adjudication, if we didn't have these lapsing rules, would consider a longer timeline. But just for space and illustrations, I just chose about 25 years as the period that I'm showcasing where these examples are going to take place. So just to reinforce the policy proposals that we have, the lapsing for adult convictions for an M3, M2, M1, unclassified misdemeanor, felony 3, and unclassified felony offenses, the individual has to remain crime-free for 10 years. So this is an example of our GAP policy. And so when we look at the felony 2 and felony 1s that are not crimes of violence, we have you have to remain crime-free for 15 years. And for those crimes of violence, and I don't have this on the slide as an example, it would be a 25-year crime-free period. So an additional consideration, I'm saying these now so I don't forget them later, is when we say crime-free, are we referring to a new conviction or a new arrest? And it's something to consider. And I know a lot of attention was placed on that question when we were considering the risk assessment instrument of what in that case, recidivism was. Was it a new arrest or a new arrest leading to a conviction? Just something to consider here. Partly the conviction, as we know, takes into account the time that it would go through the court system. And there could be examples during this 15-year period where an individual could have been arrested for a crime of violence, but not yet convicted of an offense. So how would we consider that, or how would we think about that? So I'll table that again till the implementation section, but I just wanted to make sure before I slip my mind that was on the table. So when we're looking at juvenile adjudications, so moving now from lapsing for adults to lapsing for juvenile adjudications, just a reminder that we're not counting in the prior record score consideration misdemeanor 3 or misdemeanor 2 juvenile adjudications, which is consistent with current practice. And we're suggesting that in a decay lapsing model, that at age 21, misdemeanor 1s, felony 3s, and unclassified felony juvenile adjudications lapse when the offender turns 21. Similarly, at age 25, the felony 2 and felony 1, and this is for non-crimes of violent felony 2 and felony 1s, lapse at age 25. And this schematic might be a little wrong, and it could be any crime-free period for 10 years, then those previous juvenile adjudications will lapse. So it doesn't have to be crime-free from your current offense. It could be any 10-year period of crime-free from your previous adjudication. So it in fact should be measured the other direction, but sorry about that confusion. Okay, so those are just a recap of the lapsing policies for juvenile adjudications and adult convictions. Now I'm going to run through some just very simple examples that highlight how these work in practice. We have a prior adult conviction that is felony 3. So following Mark's steps, we'll say that that's the most serious graded offense of your priors. So now we need to move to step 2 and consider whether or not this should be counted. So we need to take into account the definition for lapsing, which for these offenses, for this felony 3, is a requirement to remain crime-free for 10 years. So in this scenario, this prior would not lapse. So the F3 would be counted towards the prior record. And for a single incident felony 3, that puts that individual in the medium prior record score category. So in example 2, we have 2 priors. We have a misdemeanor 3 adult conviction and a prior felony 3 adult conviction. Neither of these would lapse because there is not 10 years between the current offense and the F3 and 10 years between the F3 and the M3. But because we're basing the prior record score on the highest statutory grade of the prior convictions or adjudications, in this example, we would only consider the F3. And so the prior record score here would be medium for this individual. In example 3, we have an individual who has a prior misdemeanor 1 adult conviction occurring about 3 or 4 years ago, and a prior felony 2 adult conviction occurring over 20 years ago from the current offense and over 15 years from that prior misdemeanor 1. So if that period for what we should consider to be counted is greater than 15 years between that misdemeanor 1 and the felony 2, that felony 2 offense, which is not a crime of violence, would lapse and not be considered. And for this individual, that misdemeanor 1 occurred during that 10-year crime-free period. So we would consider the misdemeanor 1 in the prior record score. So even though there was a felony 2 prior, in essence, this is a stale felony 2 offense or prior conviction, and we're only considering the misdemeanor 1, this individual would have a prior record score of low under the proposed prior record score calculations. So if we just start with that misdemeanor 1 that we just talked about, that is a single incident misdemeanor 1, not considered for lapsing, this individual would be in the low category. So again, our rule here is this is under our low B is a single incident misdemeanor 1. If this individual had a second misdemeanor 1 prior conviction, that individual now has multiple incidents of misdemeanor 1s. Again, neither of these would fall within our lapsing criteria of 10-year crime-free periods, so both would be counted. And it's worth in this example pointing out these 2 misdemeanor 1s are not from the same chapter, so we'll treat them a little bit different than if they were. But that individual now moves from low B, the single incident misdemeanor 1, to our medium B category of multiple incidents of misdemeanor 1, felony 3 or felony, unclassified felonies. So this individual has 2 prior misdemeanor adult convictions. Neither of those 2 convictions lapse, and they're not from the same chapter. So we see a movement of this individual from low to high. So we've identified the highest statutory grade, and then we've asked that question of how many are there? In this example, there are 2. Our earlier illustration, which I think was an M2, we stayed in low, even though there are multiple, but now we see this move across the prior record score based upon repeat offending here, the same offense grade. Example 5 looks at a situation where the individual has both an adult prior conviction and a juvenile adjudication. They're both misdemeanor ones. And so this defendant turned 21 about 6 years before the current offense. And so if we were to look at that misdemeanor 1 of the prior juvenile adjudication, prior juvenile adjudications for misdemeanor 1s lapse at 21. So we would not consider that juvenile adjudication in our calculation of prior record score. And the adult misdemeanor conviction does occur within the crime-free period for the adult lapsing definition of 10 years. So we would consider that misdemeanor 1 prior adult conviction. This individual then would have a single incident misdemeanor 1 with the juvenile adjudication lapsing and not counting in the prior record score, receive a prior record score of low. In example 6 here, we're looking at a prior adult felony 2 conviction that occurred roughly 7 years ago. So there's no lapsing because that requires a crime-free period of 15 years. If we had multiple instances of this F2, another prior adult conviction that was also an F2, and we're thinking that the offenses are from the same chapter, this individual is going to receive a prior record score of high. And as I mentioned, because of the pattern offending when they're from the same chapter, that not only will this individual receive a prior record score of high, but there'll be an increased step up on the OGS side of the equation. So even though we've spent a lot of time thinking about how to reduce the impact of prior record score by including this enhancement for second or subsequent or repeat pattern offending into our definitions of how we're considering prior record score and moving that up on the OGS scale, you would receive an enhanced recommended sentence or a longer duration or a higher level recommended sentence. So it's also important to note that in this example, if that first felony 2, so this individual did have 2 felony 2 prior convictions, and that first one lapsed, there'd be no pattern offending. And so we would not have the increase on the PRS, and we'd have the medium. Okay, example 7 are the individual has 2 prior juvenile adjudications. And so this person has a misdemeanor 1 juvenile adjudication and a felony 1 prior juvenile adjudication. And just so we can remember our rules for the misdemeanor 1, that would lapse when that individual turns 21. The felony 1 would lapse when that individual turns 25, unless it was a crime of violence. If it was a crime of violence, they need to be crime-free for 10 years since the last adjudication or conviction. So in this example, the individual turns 21. So the misdemeanor 1 would lapse. The individual turns 25. If it was a non-crime of violence felony 1, that offense would lapse. If it had been a crime of violence, 10 years would have occurred crime-free during the period from the prior F1 juvenile up to the current offense. So that also would have lapsed. And we end up with a prior record score of none for this individual. Clearly for about 15 years, there was no criminal activity for this individual, no convictions at least, or other adjudications, but especially once that individual turned an adult, there were no others leading up to the current offense. So our prior record score based on the scoring rules would be none. So before we get into discussions about our rules and our what offense grades we're characterizing into each grouping and those decision rules, but especially those lapsing provisions, I just wanted to remind you, and we don't have to use this terminology, that there's a distinction here between decay and gap policies. Again, the decay is similar to the DUI look back period, some prescribed period after you reach age 21. Those offenses lapse even if you're not crime-free during that period. But that gap requirement requires a crime-free existence for a defined period of time, similar to what we laid out here for those proposals for the adults, where there's a 10, 15, and 25-year gap periods, depending on what grade offense we're talking about as the highest statutory grade prior.
And Executive Director Bergstrom, I see your hands up if you want to hop in.
Yeah, sure. Thanks. Just a brief comment. Matt's mentioned on a couple of occasions the DUI look back period is a good example of decay. So that's in place in Pennsylvania, used for DUI offenses, has been for years. Used to be a 7-year look back, now it's a 10-year look back. An example of the gap is sort of a version of clean slate. You know, clean slate is looking at fixed periods of time, 10 years for relatively minor offenses, where there's a mechanism for the sealing of records. So it's not, you know, we're allowed to use sealed records in the prior record score. But one of the suggestions out of the work done by Drexel Law when they were working with the commission, and that we've discussed before, is the commission, in terms of recognizing lesser offenses that could be excluded from the prior record score by lapsing, is to basically look at those offenses for which a sealing of the record applies through clean slate, and exclude those for consideration in the prior record score. So that's an example of a gap policy, a crime-free 10-year period. The only caveat, and Matt mentioned this, is it's very difficult in terms of just in practice, the work of people in the field, of the probation department, of the DA's office, of defense attorneys, of really having all of the information necessary to make sure you have a crime-free period. And that's why one of the suggestions Matt made was the prosecution has responsibility for the sort of the burden for the prior record score, for establishing a prior conviction or adjudication counts in the prior record score. And the idea is the defense would have the burden in terms of showing that this should lapse. And there's some, there's always going to be some difficult calls when you're looking at lapsing policies. And one of the things that we've talked about before and is worth considering is this time on the street? So if someone has a 5 to 10 year sentence and they're released at their minimum, is that when the clock starts ticking for the look back period, or does the clock start ticking at the time of sentencing? When's the starting point for the look back period? And then what does it take to violate the crime-free period? Under our current lapsing policy for juvenile adjudications, we in effect say misdemeanor 3s are excluded, or at least one of them is excluded from tripping up that crime-free period. But beyond that, and summary offenses too, they're excluded. But beyond that, any offense counts in terms of basically voiding the crime-free period. So those are some decision rules the commission would have to make. Are there any exceptions to the rule? Or summary offenses just excluded? Is it an offense before a court of record? And also, is it a conviction or is it an arrest? Because think about that. You have a look back period where the prosecution has proved there's prior convictions. And the question is, has the person been crime-free during whatever period of time? Let's say the person was arrested during that period of time and the case is still pending, so there's not a conviction. Is that a circumstance where you should lapse the prior conviction, even though there's not, because there's no proof of a conviction? Or is this basically a sort of a case where you're saying lapsing is like grace, it's like clemency in terms of removing something, and you need proof like a conviction? You just need proof like an arrest to basically break that crime-free period. So I only point those kind of things out because there's a lot of decisions that go into a gap policy. And as Matt said, it's just a lot more complicated. And in other jurisdictions that have lapsing policies, sometimes what they've done is traded off gap for decay and maybe have a longer period of decay so that it's easier to implement. So maybe for a category that would be 10 years crime-free, it becomes 15 years, but it's a decay policy like DUI. So I just sort of throw that out. Matt's just providing you with really useful information. But when the rubber meets the road and you're trying to implement this, gap can be very difficult, even though it makes a lot of sense from a policy point of view. And so you'll have to just sort of balance the way to do this. It's very complicated, but it meets some policy goals. But the trade-off may be a longer period that you just then use a decay policy. So with that, I'll turn it back to Matt, but thank you.
And just before that, I see there's another hand raised. I'm not sure who that is. If you can just identify and go ahead.
DA Sunday has a comment.
Okay, thank you. I want to start with a hypothetical just to make sure that I'm understanding what this would look like in practice. So, and again, this is anecdotal, but a lot of the cases that we deal with, crimes of violence, okay, you may have a 17-year-old and an 18-year-old together, and they're running around. Maybe they're shooting at people, committing, again, crimes of violence, right? So the two of them get arrested. The 18-year-old gets charged with aggravated assault and maybe possession of a firearm, and the juvenile gets charged with that. And the 17-year-old gets charged with aggravated assault as well. And we'll say they adjudicated delinquent for the aggravated assault. So looking at those two individuals, we have the 18-year-old who now there is no look back really for that aggravated assault that he's convicted of. Is that correct?
I believe the policy is that it'd be 25 years crime-free to have that lapse.
Okay, so for him, it would be 25 years crime-free under the proposal to have that lapse. And then his co-conspirator, 17-year-old, would have that 10-year crime-free for that to lapse. Is that correct?
Correct.
Okay. What are your thoughts on that?
Let me start with this, and then Matt can pick up. But one of the discussions, I guess the discussion we've had during the last several meetings, and this certainly was raised in the past and during the academic review panel with Judge Tucker, was the difference between juvenile adjudications and adult convictions. So we talked exactly about the circumstance you're raising, where someone's on one side of that divide and someone's on the other side. But they're separate systems, and we talked about if on the juvenile side this warranted direct file or certification, then it would be treated just like any other conviction, and it would fall under those rules. But if it's retained in the juvenile justice system and it's an adjudication, then there are different rules. So I do appreciate that distinction, or almost the lack of distinction, when you have co-conspirators that might be days apart in age, and one's on one side and one's on the other side of that divide. But those were some of the discussions we had about having different policies. One of the other things I'll add is, under the current guidelines, and we could retain this in the new guidelines, we do have language that recognizes that we are setting in place general rules for applying prior record score. But courts have the discretion to look at a record and say the prior record score, underestimates or overestimates the impact of the prior record score. And so that's the language used right now to sort of address stale records. We see plenty of departures or mitigated sentences because of stale records. And so we're trying to codify that in a way by having a lapsing policy that addresses some of that. And we also see reports of, the prior record score caps out on this kind of thing, and it underestimates how serious this criminal history is, or how serious this offender is because of that criminal history. And so courts are allowed to depart or aggravate a sentence. And so those can still remain in place even while we have new structures around the prior record score. So
I appreciate that, Mark. And if I may, to go to the next step of my question, when you look at the amount of violence that is occurring with regard to that age group in our communities, okay, and it certainly is. I mean, I can speak from York County, and I can tell you right now that the vast majority of our daily shootings are done by individuals between the ages of 16 and maybe 20. So I guess what I would like to know is in what way does this policy for lapsing of juvenile adjudications impact public safety?
Yeah, well, I think I'd go back to what I said before, which is in those circumstances, exactly that you're describing, that could be the basis of the court aggravating or departing above the guidelines. Or you as commission members, as the commission, could decide that those types of adjudications are different. And that's one of the reasons we carved out crimes of violence, or whatever definition is used for juvenile adjudications for violent offenses, that would be treated differently. And it's certainly your call as a commission to decide how to treat them. But what we were trying to address was concerns that were raised that juvenile court was established and juvenile adjudications are different than adult convictions. But I appreciate exactly the point you're talking about. We've talked a lot about the youthful offender category being sort of 16 to 25 or 22 or something like that, where there's a lot of offending occurring and violent offending occurring. And it becomes this blended thing with the top part of the juvenile court system, and the bottom part of the criminal justice system, and trying to figure out how to get that right. So, it's a policy call, and that's certainly, that's the commission's purview. We're just sort of pulling together these recommendations based on what has been discussed since 2014 and putting forth the proposals.
Yeah, and the only thing I'll add to what Marcus said is that there's a lot of research around what's called the age crime curve, and when people age out of criminal activity, and even the scenario you gave of that age range, these lapsing criteria would extend through that period that you mentioned. So 10 years, if you're 18 is 28. So we took into consideration some of those age crime curve components when we were thinking of these lapsing criteria.
Thank you. Thanks, DA Sunday. And Representative Krajewski has a hand up.
Yes, thank you. Thank you, Judge. I had a couple questions. One was going back to something that I think was just raised earlier in the slides about, I just want to pick that up again. You had said that there could be a scenario where someone would receive a prior record score that's a high grade based on their record history, but additionally would receive the offender pattern enhancement. Is that correct?
That is correct. Yeah, we were defining that if the priors are from the same chapter as the current offense.
Okay. So to me, that it seems as though that's another kind of redundancy where that the pattern's both being reflected in how the prior record score is being calculated. But then in addition, we're also saying we're going to be placing an enhancement on top of that. That's the pattern offender enhancement.
Yeah, Rep, if I could just start on this and then turn it to Matt. We did recognize that, but we also recognize that the recommendations we're putting forward are substantial reductions in the prior record score in a lot of ways. Lapsing provision, reduction and sort of collapsing of categories, and reduction of recommendations linked to categories. And so we think, and I think that the point that the DA just made and others have made is there are real concerns about patterns of behavior, about repeat offending, about repeated victimization or victimization of vulnerable people that appropriately are built into consideration of the offense gravity score, the base sentence recommendation in any case. And we don't think that necessarily removes that from consideration as a prior conviction, because sometimes under the way the guidelines operate, if the offense occurred prior to if the conviction occurred after the commission of the current offense, it's not counted in the prior record score. So this is an opportunity to build it into consideration within the guidelines. So I think you're right. It is to some degree a redundancy or a double dipping, however you want to characterize it. But given the totality of the recommendation and the major changes to the prior record score, this is really selectively picking out repeat offenders and particularly violence and trying to make sure those are addressed as a base consideration for all of those offenses. So it is in recognition of some of the concerns raised by DA Sunday and others that you just, if we can do a lot with prior record score to try to mitigate the influence, but there are pattern behaviors, things like that, that we should not be concerned about what appears to be redundancy when we're trying to build it into the base assignment.
Okay, thank you, Representative. Is there
sorry.
another? Is there a follow-up?
Yeah, sorry, I had another question as well. And just going to prior record score and the crime-free period, does that also include, or have you given consideration to including time that someone has been incarcerated? Like, is that counting as part of their crime-free period?
Yeah, that's one thing we have not decided yet. There's been a lot of discussion about that, but we didn't build it into the policy yet. At this point, it's an open question, but I think the concern raised about crime-free period is, I mean, think about a situation where someone gets a 10 to 20 year sentence and you have a 10-year look-back period. You know, time in prison is basically, time that you weren't sort of available in the community to commit a crime. So from one view, you'd say that's not really the intent. The intent is you were in the community and you were crime-free. But the different view of that is what Matt mentioned in terms of the age crime curve. You know, someone is aging out during that period of time, and age has a lot to do with offending patterns. And so 10 years makes a difference, changing, a 25-year-old to a 35-year-old, and that makes a big difference in recidivism rates. So you can look at those two ways, and that's why happily staff passes that off to the commission as a policy decision regarding how you would define a crime-free period, because there's a lot of different views about that.
And I would also add, I hear that about the community. I mean, people can also certainly commit offenses while they're incarcerated. And so I think there is consideration for that too.
Yeah, they can. And just on that issue, because that is an important issue. We talk to the Department of Corrections a lot, into local correctional facilities. And, it's sort of situational, but in many cases, those kind of issues that happen within an institution are handled as administrative matters rather than charging the offender. It's not that there aren't charges, there are charges, but many things that would be chargeable offenses are handled administratively. And so there would be no record of an arrest or conviction. But you're right, for very serious offenses, it is, it's not unusual to see someone charged with an offense while in the institution.
Thank you.
Thank you, Representative. Judge Tucker, did you have your hand up? Yes, you do.
Yeah, for the director and the deputy, the question that was posed earlier regarding the 18-year-old and the 17-year-old, it's my understanding that if the crime is such that a person juvenile will be certified, then so be it. So there really is no distinction in that. And if it's not, then the person would be charged as a juvenile. And once he turned 18, which would be the following year, if he was arrested again for whatever reason, then that adjudication would be considered for the prior record score. Is that correct?
That's correct, Judge. And I think to your point, one of the things that we have to look at, and especially for violent offenses, as the DA was talking about, is what is the definition you're using? So, one of the narrow definition, as Matt said, is the definition that sort of looks at the Juvenile Act and looks at the definition of those cases that are subject to direct file or to certification. Now, certification is sort of a broad thing, but direct file, the automatic transfer are specified offenses. And then there's provisions about, repeat offending or use of a firearm. So you're absolutely right that there's a pool of offenses there that would be automatically filed, direct file transferred. And then there's the possibility of decertifying. And that's at least the core of what we would see as important, that these are cases that would be subject to transfer and but remained in or were returned to the juvenile justice system. So those are different, and how much weight you give to all of that and how you take that into account is a commission call, but we saw exactly that. The broader question is, should we have a broader definition like crimes of violence? So if we use the definition with 3 strikes, the definition of crimes of violence there, it's a broader definition. And so it would cover more offenses that aren't necessarily subject to transfer. And so the question is, how do you treat those? Do you treat those as, what are they treated like? Because we're trying to figure out when you have a new conviction offense and you're looking at whether to count juvenile adjudications or not, crimes of violence or violent offenses are of particular interest, and there may be different rules. There's certainly a longer timeline, but there is also, at least in the current recommendations, a crime-free period that we're looking at. So it's a gap policy. And the thing is, the commission could extend that period beyond what is recommended right now. So I think that's really an issue for the commission to discuss. How do you define violent offenses as juvenile adjudications, and what do you do with them if they stay in the juvenile justice system? Because Judge, I think you've made the point before that it's a different system. It's intended to be a different system. There's a discussion about it being different, and so how do we translate that into a policy in terms of prior record score?
Thank you.
Thank you.
Thank you. And I think just because I had the same kind of notes, but I guess part of it remedies itself potentially because of what Judge Tucker is saying, is a lot of those individuals who are on the line with the more serious offenses, they are charged and convicted as adults. So although not to say that some of them don't remain, but generally speaking, they remain for some reason in the delinquency system. So I kind of think that's sort of, I understand there's always exceptions to the rule on both end of things, but we need to make some cutoff. So I think that those are fair considerations to make. Any other, Dr. Tucker, doing a follow up with anything on that?
Yeah, and just to follow up a little bit more of it, and even if they aren't charged as an adult or transferred to the adult system, nonetheless, that crime, that conviction will be counted because it's within the 10-year or the time period, whether it's 10 or whatever the case may be.
That's correct, Judge. And that's where defining what crimes fall into that category is, how narrow, how broad we define that may address some of the concerns that are raised. But you're right, for at least up until 28, I believe is the time period that we have for crimes of violence or violent offenses that are juvenile adjudications and a crime-free period. So I think that's the policy right now. That is different than what it would be for adult convictions, but that gets to that distinction that we were talking about. But it's all subject to the commission's consideration.
Thank you.
Any other questions based on the discussion? All right,
Judge, I just have one question. I'm sorry. It's John Rago. Now,
Sure.
I'm sure this is minor, but I was just curious why, if I saw it correctly, there's different burdens for the prosecution for adults and for the juveniles. It's on the delinquent for establishing the score. Did I hear that right?
Well, Professor Rego, it's the idea is, I think, presumptively under sentencing guidelines, the burden by a preponderance of the evidence is on the prosecution
Right.
for the guidelines. They're the ones recommending the prior record score, or I guess more importantly, they're the ones that would have to meet the burden for the court to make a decision about whether something counts in the prior record score or not. And in fact, it's for that reason that one of the things we want to discuss is whether the commission wants to encourage prosecutors, the DA's office, to take a more sort of hands-on role with the preparation of the guidelines, since they're the ones that are bringing the case before the court and have the burden of proving, elements and sentencing factors and the prior record score. So we see all that, and we've historically seen that as the burden is on the prosecution. And for guidelines, it's preponderance. So the court's making the decision, but the burden is on the
And I think
prosecution.
that makes perfect sense, but
Yeah.
maybe I'm just confused. I thought
And then-
was the burdens flipped for the juvenile side?
Well, and that's not for the juveniles, but for the idea of any kind of lapsing. What we're saying
Right.
is lapsing policy, whether it's adult convictions or juvenile adjudications, is really removing a conviction or adjudication from the prior record score. And so the
Okay.
burden for that would be on the defense. And that's not unlike, transfer cases on the juvenile side, where,
Right.
you have a direct file or a transfer to criminal court and the burden's on the prosecution. And then to decertify, the burden is flipped and the burden is then on the defense
Got it.
to move it back to juvenile court.
Okay. Thanks, Mark. Thanks, man.
Thank you.
anything further? All right, so we can continue.
So for this module, this is really the last slide, and I'm not sure beyond the discussions we've just had, how much additional discussion members would like to have regarding alternative definitions of this crime-free period, or thinking about moving from gap to decay policies. If there's any proposals or additional thought above and beyond, or helping us again define what we might think of for crime-free period, whether or not time in state confinement would be considered as part of the crime-free period, et cetera, all the issues we laid out before.
The purpose of crime-free period is crime-free in the community. So if someone, like Mark said, if someone's serving 10 years, I don't think you can count that. We want to encourage people to be crime-free. I'm not saying people act because they're thinking, oh, this won't, hurt me in the sentencing guidelines in the future. But, certainly I think crime-free has to be crime-free in that regard. I think the bigger question is decay versus gap. Decay is probably, I don't know, somewhat easier to calculate, like it's black and white. But I sort of like how you've laid it out so far. I mean, my only quibble might be, and I know Mark said something about this before, is with the ungraded felonies. And I realize most of those are PWIs or deliveries. But to me, those are the same as an F2 or F1, at least most of the drug deliveries. And if you're going to have someone that's a serial drug dealer in this day and age, that goes hand in hand with violent crime. So yeah, that would be my only tweak, but certainly understand what you're trying to do.
Hey, Judge, and on that point about the ungraded felonies and particularly PWID, that's really where all the action is on those. That's something the commission's, I guess, struggled with over the years and took sort of a hybrid approach to it years ago. And you might recall all of this when you were, a DA and PDAA and working with the commission on these things. But, the commission sort of split the difference in terms of prior record score, basically giving drug felonies 2 points or 3 points, depending on weight, and then excluding them from RFL and REVOC. So they gave them sort of equivalent points to felony twos at times, and felony ones, but they didn't include them in RFL and REVOC. And under this new approach where it's more categorical, we sort of had to choose sides. And so what we did was we did go with the lower category to exclude them so they'd cap out basically at medium. But then we came up with that idea of having two categories in the prior record score where we recognize second and subsequent convictions as different than first convictions to sort of offset that difference. One of the things we've been trying to do also is keep in mind, how do you automate this and how do you address out-of-state offenses? And that's always complicated. It's complicated to do when you're not automating it. It's more complicated when you are. And so having clean rules for what applies and how it applies is part of that process. So I think you raised a good issue, and we'll move in the direction the commission wants us to move. But that's sort of the background on how we got to where we did on the drug things. And then, as Matt said, when we look at disproportionality and especially prior record score, drug offenses make a big contribution to that. So if we're trying to reduce the disproportionality in the prior record score, one way to address some of those issues is around how we treat drug felonies as part of the prior record score. So,
right. I just think in a way that's manipulating things to what they aren't, in a sense. But I certainly understand that, and I agree, Mark. It's hard to thread the needle with those drug felonies because there are different grades of those, and I don't want to complicate this anymore.
Right.
I don't know what the answer is, but I just thought I'd raise that as a tough issue, I think, to look at as to where does that go. And I brought up with Matt over lunch the same thing Representative Krajewski brought up about sort of the double counting, because I wasn't sure how we were going to do that. If it's second and subsequent, then do we still get a bump on prior record scores? And you guys have now Matt explained it to me over lunch.
I think we said yes.
No, you did. But I guess just even conceptually, that's a little bit, maybe, I agree. That's probably the best practical way of dealing with this issue. The way you guys have laid it out conceptually or theoretically, I don't know if it's the best, but practically it seems to probably will work.
Yeah. And I guess, two things. One is, as you know, the guidelines have gotten complicated over time, and we're trying to uncomplicate them or streamline them with some of this. And one of the complications has been the prior conviction definition, which we think is a good definition. You should have a conviction before the commission of the current offense for something to be counted in the prior record score. But what that excludes then is the consideration of those offenses in terms of consideration at all. And that's where using them on the OGS axis helps you with that because those do count in terms of the doubling of the statutory max. So yeah, we're trying to, thread the needle on this one, but I think that's a key part of it. So anyhow, I think you're raising good issues. I'm not sure that, we found the perfect solution, but we're trying to, try to accommodate a bunch of these things.
Any other questions? Okay, so I just had a couple of notes. This was thrown out, no one commented on it yet, but just giving my thoughts on the question of arrests versus convictions based on everything we went through for the risk assessment tool. And there were a lot of concerns with the racial disparity and locations of the state for an arrest versus a conviction. I mean, I think we would do a disservice to make it arrest. I think it's best to just go with convictions for the calculation. Just a couple other quick notes I had. I'm agreeing that the time incarcerated shouldn't count, but then there was a sort of subcategory of that regarding if there's a violation. And it really depends where we're at, if we're with felonies in the state or with misdemeanors or, but I just made some notes on concepts because we're also working on parole guidelines for violations, correct? So I'm wondering because if the violation is a new offense, that's already going to be covered because it's going to be a subsequent conviction unless it happens near the end of the gap period. But I didn't know if there's violations for technical offenses where there's incarceration. Let's say hypothetically you served 5 to 10, you did 5 years, you get hit and you do another 6 months. Do we say 5 years, 6 months from the look back? I mean, I don't have an answer to that, but I think those are the kinds of nitty gritties. But I just wanted to throw those out there.
Hey, Judge, on that last part, we did spend a lot of time talking about that, and that's why we wanted to bring to the commission the ease of application for decay versus gap, because that whole issue of recommitment, especially on a technical violation, do you restart the clock on the look back period? Do you, how does that sort of fit in? Because if you're saying it's street time, how do you do that? And then you can see how hyper technical that becomes in trying to determine the look back period and all of that. So there's there's difficult application issues when you go down the path of gap, and that's why the commission will have to have just clear rules about how it applies. And then the thing on arrest versus conviction, the commission's been through all of that, and clearly for risk assessment for sentencing, it's all about convictions, not arrests. But think about this scenario. You have someone with a substantial criminal history, a substantial prior record score, and they're sort of on the cusp of, like, let's say a 15-year look back period as far as crime-free behavior. And define it however you want, but they're out on the street for approaching 15 years. And sometime in the last year, they were arrested for a violent offense. And the case is moving through the system. But the offense for which they're in court today, and let's say we hit the 15-year mark, the offense they're in court for today, the court is making a determination about whether to count the prior record score or not based on law-abiding behavior. And you have an arrest, you might even have detention right now because of a violent offense that's charged, but you don't have the conviction yet. And we'd be in the circumstance of the court, the present court, eliminating the prior record score because of an arrest that doesn't have a conviction. I'm saying, an arrest without a conviction because there's not a conviction. And that's the only situation where we're trying to sort of figure out what's the appropriate direction on this, because there's going to be behavior during the look back period that really calls into question whether the defendant should get the benefit of a lapsing policy. And if we just link that to conviction, the delay in a conviction for someone who might be detained on that charge, that's quite a quite a reduction in the prior record score. So anyhow, it's just, that's the issue we were struggling with. We generally think conviction should be used, but there could be cases pending at the time of the sentencing where absent considering just arrest, you lapse the entire prior record score.
Isn't that, I mean, in that small period, isn't that the kind of thing that we talked about before, where there hits a point where statistically those individuals are much more or no greater likely than somebody who hasn't offended before? And isn't that the kind of thing that's the outlying situation where arguments are made by counsel and the court's looking at the factual scenarios versus going to arrests where there's all kinds of other considerations that we've looked at over and over?
Right. No, you're absolutely right. And that's why I mentioned that policy, that maybe the mechanism is, go with conviction, but the court in that circumstance could say, but I'm departing from the guidelines because of this fact, this issue that's sort of in play. The reason we raised the issue sort of from the other direction was, think about all the work we've done with parole guidelines and sort of the premise that there is no right to parole. So the starting point is, you have a confinement sentence and you earn the right to parole. And so, framing that in terms of earning the right to a lapsing of a prior record score, it sort of shifts the burden or changes the view. So that's why we raised it. But you may be right. The remedy may be use conviction, keep it clean, but note that the court may depart from the guidelines or aggravate based on that factor.
I have two hands up. I don't know who was first, but Representative Krajewski, you're first in line on my screen.
Thank you. I just had a few comments. It seems to me, even in the discussion, that the K model also just simpler in trying to calculate the impact that they have when we're talking about prior records. And I also just wanted to circle back to the question about incarceration counting for time. I think just to the other points I just want to make is there is just inherent in some of the groupings a bit of an imbalance because, for an M3, you may not actually end up being sentenced to any incarceration time, but for another charge in that range, you might. And so in that sense, someone who's serving incarceration time has to do that 10-year period on top of their time, whereas someone who was not incarcerated at all in that same gap just has to do 10 years. So in a way, by not counting that, we are having that person have more time in which they have to be crime-free, which is part of me making that case for why we could consider it. And then the other point I just wanted to say also is just based on the sentences that each of those categories would get, I don't, unless maybe some of the more serious ones, I don't think there would be a scenario where the person would do their entire crime-free period while they're incarcerated. So I just wanted to make those points. And then I think the only other thing that I also wanted to raise, and this kind of connected, but just looking at the adult convictions for that first 10-year crime-free period grouping, there is a fair amount of range in terms of the offenses that are included in that, from an M3 to an F3. An M3 being something very simple and like kind of petty crimes, then F3 starting to get into some of the more serious stuff. But those are all being counted under the same level in terms of potentially being included in your prior record score. So I guess I'm wondering if there's even an opportunity to break that down a little bit more, because I don't think that an M3 and an F3 should necessarily be given the same consideration, since I think there's a fair amount of range in terms of like the seriousness of those crimes.
Thank you, Representative. Judge Tucker, are you hand still up, or did you just not move your little icon?
Yes. Going back to the arrest versus conviction scenario, we see that instance now where you have an individual who is being sentenced and has an open case pending. And oftentimes what will happen is that case will be, the open case will be postponed until the sentencing rather will be postponed until the open case is resolved. And you also have those situations involving probation and parole violations, where that case is postponed until the probation is postponed until the open case is resolved. So this is nothing new, is what my point is. We see this on a daily basis, but I do think that the arrests would be fundamentally unfair as opposed to a conviction in terms of sentencing. In terms of a conviction, rather.
Thank you, Judge Tucker. And just something that crossed my mind a couple times. It sounds like the crime-free period for juveniles excludes M3s. If there's M3s in the middle there, did I catch that, or was that?
That's correct under the current policy. And so the question is, if we're, as we're rebuilding or building all of this, what the commission will have to decide is what counts as a conviction and what doesn't count. And so I think everyone agrees that it's you exclude summary offenses. And so what about, is there a difference between minor courts and courts of record? Or do you exclude M3s? Or do you basically say any misdemeanor or felony conviction breaks that crime-free period? So that's just a call by the commission, but those are some things to think about.
But that's also something we can consider even for adults.
Sure,
correct?
absolutely. Yep.
Okay.
Yep.
Because I just see cases a lot where somebody had something serious a long time ago, and then they have a little bump or two that are so minor, but it would preclude them. Now, I recognize the impact's going to be a little different in that we're not jumping up to tenfold anymore on the prior record score, and we still have all the judicial discretion. Representative Stevens, go ahead.
Thank you. Mark or Matt, it seems interesting to address Mark on the TV screen when Matt's like 8 feet from me. But when we did the risk assessment, didn't we, I forget whether, I know we did a lot of work on that. And at one point in time, when we were considering this arrest versus conviction, I feel like at some point we talked about the process moving past the preliminary hearing stage, so that there was some type of probable cause determination. Did that make it into the final risk assessment instrument, or was that just, where did that land, and could that have an application here?
Yeah, that was, you're right, Representative Stevens. That was one of the steps upon the process. In fact, that was pretty early in the process that we said we wouldn't just take raw arrests. We would make sure that we were looking at cases that were bound over to common pleas court, and that would be our starting point. And we did it for two reasons. One, because then if it was inappropriate arrest, things like that, you'd filter out those cases. And secondly, you could automate it because we could use the CPCMS data and the bind over as a flag for that case being counted and considered. So there was a lot of purpose for that. But as a result of the public hearings and the discussion of risk assessment, the commission moved to go with convictions alone. So along the lines of what Judge Bernstein said. So the policy right now with risk assessment is for conviction based.
But I guess what I'm wondering is, this has a different application, right?
Right.
That was being used, and I know that we were advising that it should be used for informational purposes. I know that there was a concern that it was going to be used to impact a sentence.
Right.
in this instance, as we define crime-free period, I just wonder whether there might be an application there where you've had a probable cause determination made regarding particular conduct, and whether that might be something we could consider, and whether that, I know we were already talking about how gap is more complicated than decay, and this, of course, only further complicates things. But do you know of any jurisdictions that do it that way, or is there, and do you think that is a possibility for us to consider?
Well, I'm not aware of any states that do it that way. But I think it is a possibility, and that's why we raised it in terms of like, how do you view lapsing? And again, going back to just sort of the example of parole, there are states that have parole and there's a presumption of parole. And then there's states that have parole, like Pennsylvania, where there's no right to parole. And so the characterization of parole, whether it's presumptive or no right, really sort of shapes how parole operates. And so when we're talking about lapsing policies, the starting point is there are convictions that count in the prior record score. They're already there. And so the question is, how do you approach lapsing? Is it viewed as sort of a right, or is it viewed as no right? Is it a presumption or not a presumption? And that's why I said, those two, the characterization of that, I think, has a lot to do with how you approach it then. Because if you say you have a prior conviction and you have to earn a lapsing, the burden's on the defense, you have to earn a lapsing, then you can have, I think, different standards. And what you're talking about might be something the commission considers, that, if there's probable cause, if the case is bound over for trial, if there's some indication that an independent court reviewed this and it's not, a bad arrest, it's not other stuff like that, that might be different, and it might be used in this circumstance. But as Judge Tucker and Judge Bernstein said, the other approach, even if it's not a right, is to say, let's just be generous in terms of saying there must be a conviction in order to lose that lapsing provision. And so it's just, again, the great thing about being staff is we can push the tough decisions to the commission, because that's really, I think that is the call. Yep.
Okay. Thank you.
Thank you.
Judge Tucker, did you have a comment?
I apologize. I meant to take my hand down before, so no.
Okay. Well, shockingly, I have a comment. So, just being playing devil's advocate, because as a former prosecutor, I get the reasons and what we see in real life considering certain arrests. But the problem with the probable cause determination is, so most people don't meet their attorney until the prelim, and most people are represented by public defenders, and in my area, both public defenders and privately retained waive prelims so frequently. So there's very rarely in our area preliminary hearings held where there is a probable cause determination. It may go up to the next level, but it's just because somebody signed a piece of paper and on they go. So just in terms of conceptually, yeah, if it had been before a court and there was a burden and it had to be established, but in our area, at least, it's almost always waived. Just food for thought. Again, I can always argue both sides of things, but I just think that's worth pointing out. So I guess with that, Matt, you can go ahead, correct?
We are at a spot where I'm going to have to load the next set of slides. I don't know if anyone wants to think about a very short break or just keep forging on.
What do you think about the concept of a 10-minute break? Turn it over to the executive director.
I think that's a wonderful idea. And maybe we reconvene at 3:15 and and we'll be down to our last 45 minutes.
Okay, so we'll take the break and we'll see everybody back here at 3:15. All right, so let's continue. This is our last section, I guess, before we break for the afternoon. Matt, if you go ahead.
Great. Thanks. Just make sure I can advance. Oops, there we go. So we're at the point now where we're looking at the combination of our proposals and policies from both OGS and from the prior record score. So 303.9 basically says that that intersection leads to the sentencing recommendations that are found in the basic sentencing matrix. And it will specify a range of sentences that should be considered for court for each combination of these OGS and PRS. Earlier, Mark did a nice job really describing some of the levels and as you move up from on the OGS and across on PRS, that there are different levels. And we saw that, for example, there's an increase in the number of cells associated with restorative sanctions, talked about community service. In the next level, talking about probation and so forth. But so given time considerations, I thought I would skip ahead and just focus on some scenarios that I've generated, again, along with working with the Research and Data Analysis Unit and Mark and others, that highlight the differences between the decision rules that are in the 7th edition and the decision rules in the 8th edition. I want to assure that there's a little bit of time for Mark to wrap things up and talk about next steps. But we'll see, this to me is really where the rubber hits the road in terms of the policies in action. So in this first scenario, and it's very similar to what the exercises we've been going through for the last several meetings, is we're looking at a situation where prior record score is 0. And the current conviction offense is an aggravated assault with attempted serious bodily injury, which is a felony 1. With a statutory max of 240 months. So we have under the 7th edition guidelines, it's an OGS 10 with a prior record score of 0. The standard range sentence is 22 to 36 months state confinement. It's a level 5 sentence recommendation. When we look at the 8th edition recommendation, it's an OGS of 22. Prior record score is none, and the standard range is 24 to less than 30 months, which puts it in the level D state confinement, county confinement exception. And what's nice, just to reinforce, is what Mark started with today, which was how did we go about our OGS assignments? And really in this new approach is grounding the new assignments of the OGS squarely within the old standard range of the 7th edition. So if it was 22 to 36, we now see it's 24 to less than 30. So this first example really only just reinforces the OGS assignments, since we're not looking at the impact of prior record score on the duration. So for all of these scenarios, I'm just going to start with prior record scores 0 or none, and then see what the implication of adding some prior convictions. And I'll note for this set of illustrations or scenarios, they're all adult convictions. Would work the same if with the juvenile adjudications, and lapsing is not considered here. They're excluded from lapsing, so they're being counted in the prior record score calculation. There could have been more advanced scenarios where we had adjudications and convictions and some lapse, but this is just to see when we intersect, once we have established what the OGS score is, and what we established what the PRS score is, what are the standard range recommendations on the 7th edition compared to the 8th? So in this, when we start with a burglary home, no person present, 3502A2, it's an F1 with a statutory max of 240 months. This is an OGS 7 with PRS 0 in the 7th edition. Standard range is a 6 to 14 month county confinement level 3. In the proposed recommendations, this is an OGS 15. Prior record score is none, and that standard range is 6 to 8 months. Level C, county confinement with the possibility also of restrictive conditions of probation. So we see again, it's squarely, because the ranges are narrow, it's within the standard range, but in this assignment, at the lower end of the standard range recommendation for the 8th edition being at OGS 15. So if we were to add some prior convictions here, we have 2 priors. You could see they're not from the same chapter. So we have 3929A1, retail theft, taking merchandise greater than $1,000, firearm or motor vehicle. It's an F3, statutory max is 84 months. We also have 3701 AII, robbery, threatening serious bodily injury, which is a felony 1 with a statutory max of 240 months. So when we look at the 7th edition recommendation, this is an OGS of 7, and now the prior record score is 5. We had a 4-point prior for the robbery and a 1-point prior for the retail theft, giving it a PRS of 5. So just taking a look at the basic sentencing matrix, the intersection of the OGS at level 7 and PRS 5, the standard range sentence is 24 to 30 months state confinement, falling within our level 4 sentence on the 7th edition basic matrix. When we now look at the 8th edition recommendation, then we utilize our scoring sheet here. There were 2 priors. Let's go back really quick. There's a prior felony 1 and there's a prior felony 3. The felony 1 is a crime of violence. So we start at our top and say, do we have top left? Is there any felony 1 or felony 2 crime of violence? The answer is yes. We enter in the 1 felony 1, and the prior record score for this scenario is medium because there's 1 prior crime of violence, and we're not considering the F3 since we're looking at the most serious prior offense or conviction or adjudication with the highest statutory grade. So we have PRS medium. In this case, now looking at the 8th edition guidelines for simplicity, I've chopped the top off so it would go much higher, of course, but it's pretty hard to read even this tiny. So I tried to make it readable, but we have our new assignment of OGS 15, prior record score medium. We end up with a standard range recommendation here of 8 to 10 months county confinement level C. So in this example, when we compare those 2 scenarios, first column there is the 7th edition recommendation. The second is the 8th edition recommendation. The first row going horizontal is what the standard range recommendation when PRS is 0. So we see 6 to 14 and 6 to 8 months for the 8th edition. And then when it's at, this should say prior record score 5 or medium, it's 24 to 30 months and 8 to 10. And this ratio is, I'm taking the lower limit of the standard range. So 24 divided by 6, the lower limit of when it's with the prior record, and with no prior record score, it's 4 times the amount under the current guidelines, and a little about 1.3 or 1.4 for the 8th edition guidelines. So one of the goals again was to rely on OGS to make the recommendation, like the bulk of the sentence recommendation coming from the OGS. We see here a pretty significant decrease in the recommendation under the 8th edition guideline. So when we move now to scenario 3, we're looking at an example where the adult prior is from the same chapter. But as I mentioned, we're just going to start with PRS equals 0 and none, just to see where those assignments were made for the current offense. So this is a simple assault, attempt or cause bodily injury. It's a misdemeanor 2 with a statutory max of 24 months. Under the 7th edition, it would be OGS 3. PRS is equal to 0. Standard range is RS to 1, and this is a level 2 sentence. And then in the 8th edition proposed, it's an OGS 7, PRS none. our standard range sentence is 24 months probation, being a level B or probation sentence. So squarely in the middle of that standard range when PRS is 0. The prior conviction that we chose as the example here is 2706A1, terroristic threats with an intent to terrorize. So it's a misdemeanor 1 with a statutory max of 60 months. In the 7th edition recommendations, since this is the first misdemeanor 1 offense, for 1 point to be added, you have to be convicted of 2 or 3 misdemeanors. So it doesn't impact the prior record score for this offender. So the standard range recommendation remains at RS to 1. For this individual, for the 8th edition, we would have that M1 counting and the prior record score would be low, and the standard range would be 36 months. So let me just explain how we end up at 36 months as the standard range recommendation. As I mentioned, this would be, we'd first consider what the prior record score for this offender is. Since it's 1 misdemeanor, it would be characterized as low for the prior record score. And when we come to looking at the grid, and there's a typo here, my apology, because of the pattern offending, we would increase the OGS 1. So we'd move from 7 to 8, and then we'd move over, because they're from the same chapter, we'd move over 1 on the prior record score from none to low. So this individual, rather than just moving from 24 months to 30 months, if they remained at OGS 7, moves from 24 months to 36 months by moving over 1 and up. So this is that example that we were talking about earlier of the impact of pattern offending or offenses from the same chapter, increasing both the prior record score as well as the OGS assignment. So when we look at the 7th edition, it's the same recommendation of RS to 1. Given our decision rules here for having a true 0 as none, this individual is now classified as low for prior record score and then has that enhancement moving up the OGS for pattern offending. So at least in terms of the months, it's 1.5 times greater as the punishment duration for the probation recommendation. And as I said, for 7th edition, it remains the same. So we have a different outcome here for thinking about classifying those misdemeanor 1s into that low category of prior record score. This last scenario here looks at a serious current conviction. So we're looking at a robbery that inflicts serious bodily injury, 3701 A1I, an F1 with a statutory max of 240 months. Again, starting with the prior record score of 0. In the 7th edition, this is an OGS 12, standard range of 48 to 66, state confinement recommendation, level 5. In our new proposed 8th edition, it's an OGS 26. Again, you could see the footing of that standard range is squarely within the 7th edition standard range. So instead of 48 to 66, a little bit narrower here at 48 to 60 months recommendation, falling within our level E. So again, a state confinement recommendation. For this example, looking at 2 priors that under the old counting rules are 2-point priors, criminal trespassing with building break-in and F2, statutory maximum 120 months. And then we're looking at theft by receiving stolen property, $100,000 to less than $500,000, an F2 statutory max 120 months. So again, the current conviction is chapter 37. These priors are from chapter 35 and chapter 39. So we're not having a repeat offending pattern. So under this circumstance, we would have OGS 12, prior record score is 4, so that the standard range sentence recommendation is 72 to 90 months. And it's a level 5 offense. For the eighth edition recommendations, this would lead to prior record score high with the OGS 26, and we see a standard range sentence of 66 to 78 months. So this is would fall under our RFL category because these were not crimes of violence. There's two F2s. And so we would have then by definition, prior record score under the proposed eighth edition would be high, but since it's not crimes of violence, it would fall under RFL. And so we end up with that 66 to 78. So when we're making the comparison as we move up on the OGS scales, the differential of those ratios, remember earlier was 4 to about 1.4. Now we're looking at 1.5 to 1.4. So 72, the lower limit of the standard range of 72 months when there was a prior record compared to 48 months of the lower limit of the standard range, seventh edition, compared to 66 months of the lower limit of the standard range when it's an RFL under the eighth edition guidelines compared to the lower limit of 48 months gets us that ratio of 1.4. So I think, we saw a couple different scenarios where obviously I think what some fundamentals, and then I'll turn it over for Mark for a summary review of a number of concepts. But when we have our PRS none or PRS 0, we chose those assignments for the OGS with new eighth edition to be in line with the standard range of the seventh. So that was really scenario 1. When we're lower on the grid, that's really where that reducing the impact of the prior record score at lower OGS levels is where we start seeing that 5, 6, 7, 9, 10 times the impact of the prior record score on the recommended sentence duration in the seventh edition. So we saw a pretty significant reduction when we're applying the new prior record score. We then saw the pattern offending increases both the OGS and the prior record score. And the example that I chose showed that under the seventh edition, that misdemeanor 1 prior had no impact on the recommendation under the seventh edition guidelines and had about a 1.5 times impact on recommendation for probation duration when looking at going up 1 OGS and over 1 prior record score to low. And then finally, at the top of the grid, that's where, because the numbers are so large in the seventh edition, there's not that much room to say 10 times the amount when you're starting at something like OGS 12. So as we move over to a prior record score of 4, it's 1.5 times. Ours is very close with the recommendation for RFL here at 1.4. So I hope this shows like how under different circumstances, and sure, we could have tried lots of different combinations of adjudications and felony prior convictions, different OGS levels. But I wanted to give a flavor of a few just to see, we've been trying to think what happens when we start applying the 8th edition guidelines using these rules is really what some of these examples did. So I'll certainly open it up to questions and then maybe turn it over to Mark for some final comments.
Anybody with any questions? Just, can I back up for, I'm not sure if I just missed something on the simple assault scenario. And maybe I just misunderstood this. You gave the example, if they had a prior conviction so that they're a low, and then you walked us through how we move up and over, and that the standard range under the 8th edition is 36 months probation. Is that correct?
Yeah, so we're saying they're from the same chapter 27. So that would be then this pattern offending. So when I come to this grid here, essentially they're moving from the OGS 7 to OGS 8. And I apologize for the typo in the slide. It's 7 to 9. So you're effectively moving up 1. And then we're moving from none prior record score to low prior record score. So we're moving over one. So that's how we end up being diagonally across from 24 months to the 36 months that's shown here.
But if it's a simple assault with an M2, isn't the statutory max 2 years?
I'll defer to Mark on that one real quick.
Yeah, that is correct. And just like how the guidelines operate generally, we're capped by the statute. So in that case, although the recommendation is 36 months probation, the court would be capped at two years, but the court could then aggravate and give a jail sentence or use restrictive conditions as the way to accommodate that.
Does that happen frequently with this new scenario, or is it?
I think that's one of the things with, as Matt said, there's a lot of action at the bottom of the matrix. That's where there's a lot of numbers, and it's pretty compressed because of the short statutory maxes and limits. So for M1s and M2s, you run into that problem at times, and especially when we're trying to recommend the use of probation as sort of a primary response. Probation is based on the max, whereas confinement, we focus on the min. And so you get into exactly this scenario. So maybe that's something we have to look at in terms of how we address either the step up, step down, or the aggravated range in terms of probation. I think the sense of this level of the guidelines is to try to use intensity, so restrictive conditions with probation, as opposed to confinement, because you're moving over to a different disposition. So maybe we should look at something about intensity of supervision in terms of the adjustment at probation instead of just the steps that we're talking about. But good point. And like I said, I think it's particular to M3s and M2s because of the short statutory max, but you've raised a good point with this.
Thank you. Anybody else? All right, are we turning it back over to the executive director to conclude?
Sure, Matt, unless you have anything else to add.
Oh, and thank you for that, Judge. Shows what happens when you make these scenarios in a vacuum fast. So my apologies for not having a real world scenario that's legal.
Well, but I think it's really good that it happened, because it's what's going to happen out there, and how do we address that? And is there something that we can do in the commission to address it before it gets out there?
Judge, this is Ryan. If I may just give one point of context, it occurs currently in our system, as Mark mentioned. If you think of the basic sentencing matrix, when we talk about it from an education and outreach perspective, I often refer to it, it's like the movie poster. It gives you a little bit of a visual of what it is, but it's really about the use of SGS Web. When you're in SGS Web, we have all sorts of rules of the road that will flag cases when we see statutory maximums exceeding, or the recommendation exceeding the statutory maximum. So.
Did I lose him, or is he?
No, we good to go? Okay, thanks, Judge. I'll try to bring this all to a close, and we'll be done by 4 p.m. as promised. So, where we started this morning was with the discussion of the process we've been undertaking since 2014. And as you can see, even if members disagree with one recommendation or another, one proposal, or the whole enterprise that we're engaged in, it's been a long process. I think a lot of work has gone into it, and a lot of voices have been heard from. And it will require more work as well. But at some point, we have to package together something and start engaging the public. And it's the public at large and practitioners, but also all of the various associations and groups that we work with all the time. So as I said before, the trial judges, whether it's the PJ Packham committee or the criminal law section or others like that, just sitting down, talking, or giving a presentation to trial judges and engaging in this kind of discussion with trial judges. Certainly the DA's Association, a key player in all of this, and really looking for an opportunity to, to sort of present them with a package, not done, but a package to make very specific recommendations or identify flaws and help to improve the product before we're, trying to move towards adoption. The public defenders and the defense bar generally, all of the groups that we work with in terms of the Pennsylvania Bar Institute and others. So very important groups like that. We also have groups like PCCD, where they have at least 3 committees that really we should be engaging with in trying to present information as a starting point. Clearly the CJAPs, and Ryan's going to be talking to them during their conference. We have the Chief Probation Officers Association, really involved because of all the recent reforms and the whole idea of funding linked to promoting probation services. And we have the Task Force on Child Pornography. So 3 groups very actively involved in a lot of this that we should be talking to. There's the Juvenile Court Judges Commission, just the discussion of juvenile adjudications or youthful offenders or transfer cases, having them engaged. So I've been invited to meet with the Juvenile Court Judges Commission in February. And so that's another opportunity to talk about what we're developing or what we have developed and get some feedback before we're too far down the line. The victim advocate, talking to the victim advocate about all of this and the impacts, and then specific associations like PCAR and PCADV. So, lots of groups that we should engage with, but what we need is to be able to take something to them and say, here's a starting point. What do you think? And so that's why I've been sort of pushing aggressively this year to really have us move towards building something that we can take out. And the idea is it's not perfect, and there's a lot of issues we should look at. And it would be really helpful if the commission at this point was at a point where there are specific recommendations or suggestions or reactions to what's been developed to date, that we could do some modification. But it would be great if we could tomorrow during the commission meeting approve generally something that we could publish for the purpose of having public hearings, just to receive comments from the public, reactions. And as I said, with the OGS assignments, that's fertile ground. I mean, when you have a couple thousand assignments, it's helpful to have a lot of people looking at it. And some of them might be stupid assignments, but we're early in the process in terms of we can make changes. As Judge Marsico said, there might be some assignments that sort of fit the blueprint that we have, but just doesn't quite work. And the commission might override the rules of the road we have and decide on something different. And that's certainly true of prior record score. That's certainly true of lapsing policies. It's certainly true of what the aggravated mitigated range looks like, how long it is and how it applies. So I think there's more work to do, but at some point we have to be able to present a package so that other people can be involved in the discussion. And so that's what I'm really hoping that, hoping that we're pretty close to that we can pull together something that we can put out there and start receiving comment on, and that we can talk to groups about, and continue to work on the process. And one of the suggestions that I'll make tomorrow during the commission meeting is if the commission as a whole can be supportive or is supportive of this sort of framework, staff can go through and package the information based on what we have right now. And that includes, text of the guidelines, or at least provisions of the guidelines that would be modified in the text, so that we can put that out there, put it together, and have the commission basically authorize the chair and vice chair to review and approve the publication of that information. So the commission as a whole approve the the framework of this, and then delegate to the chair and vice chair the ability to sort of sign off on whatever is going to be published. That way, early next year, February, March, we could have public hearings. We could be around the Commonwealth visiting with counties and with constituencies to sort of review all of this. And then in February and again in June, we have an opportunity to continue to work these guidelines so that we're moving this forward towards an eventual adoption, hopefully by the end of next year. So I wanted to put that out as sort of the big picture, what the intent is. And so let me talk about, some of the specifics that should be part of that if people are attending the dinner tonight, that we have an opportunity to just informally discuss this as part of like, what are the next steps? And then tomorrow during the commission meeting, during the part where we talk about policy, we have an opportunity to make a decision about whether it's time to go forward with this or we need more time to work on it. But times are running. So just wanted to raise that. So here's 3 documents that I think would be really helpful for members to consider as part of this. And they're 3 documents you already have, but for those that are present in the meeting or at the dinner meeting tonight, I've asked Jay Dean to make copies of this. So the one document is the matrix. Take a look at that, have that available to look at it, suggest any kind of changes that might be worth considering. The second is the list of example offenses, where we try to sort of map the current guidelines to the proposed OGS assignments. We didn't do it for all 2,000 some offenses, but we did it for maybe 50 offenses. And that includes the drug offenses that we broke out into the new categories. So take a look at those, see if they make sense or if you'd move things around, and if so, how. But one of the things we tried to do with that was to provide sort of groups of offenses so that you could sort of think about that whole issue of uniformity. Do the things sort of fit together in the new OGS assignments? And proportionality, do they sort of fit in terms of the ranking of the offenses and where we plug them into the system? So that would be helpful to look at that. And then the third document, and we sort of promised to talk about this, but we promised to talk about a lot of stuff. But it's the adjustments and enhancements. So there's a document about the tiniest font you'll ever see, but if you have a computer, it looks really big if you want it to. But the adjustments and enhancements is really about what are those step up, step downs that we think are important. The statutory ones, the enhancement ones, but also the ones that are common reasons for aggravated or mitigated sentences. And so what are those things that it makes sense to build in? And look, we recommended weights for those, like how many steps up, how many steps down. The commission might say, yeah, that's not enough. Maybe for pattern behavior, it should be 2 or 3 steps instead of 1 step. So, those are things too about what's the right weight that you give to these factors. How do you build that all in? And then are there other factors that should be added? I had mentioned public trust or breach of trust as one of those issues. I had mentioned when someone is a victim of domestic violence, but is is a defendant in the case, is an offender, is there some role for mitigation? Because we see that in sentences, especially for murder 3, where a person is convicted of murder 3, but has been in an abusive relationship for a long period of time. So those are just things to think about. And also, are there things that we should do more research on, that we should try to reach out to people? I've been talking to the Juvenile Court Judges Commission, to the staff, to Rick Steele, and ask him about some of the issues you've raised in terms of lapsing of juvenile adjudications, or what is a violent offense, what definition should we use, and so forth. So those can be really productive discussions. So I just mentioned those 3 documents would be helpful for you to review and to comment on, so that we could build those into sort of this ongoing review. And then thinking about, can we get to a point where we move this to the public and start engaging the public, recognizing it is not a done deal yet, it is not the final product, but we need to move this process along. Some of the specifics to think about as far as the guidelines include the OGS assignments, whether it makes sense to delegate to the chair and vice chair sort of approval of a document to put out there. When we get to general sentence recommendations, we haven't talked about this a lot, but are there things about the matrix that you would change or modify? The width of the ranges, aggravated, mitigated, duration, increases in OGS from one step to the next, the sentencing levels that have been developed, but other issues like concurrent consecutive. I mean, we've talked about this forever, but are there any rules that the commission should consider or any guidance the commission should offer in terms of the use of concurrent or consecutive sentencing? Because we've spent a lot of time on these individual sentence recommendations, but when you have more than one offense, there can be a doubling without any kind of reason, any kind of rhyme or reason. And it's not that it's right or wrong, it's just that there can be great consistency across the Commonwealth or in two side-by-side cases. And while that's part of the exercise of the discretion of the court, all of this is about the discretion of the court. So we're trying to provide, basic starting points for sentencing. And when we're silent on concurrent consecutive, that can undermine the idea of uniformity and proportionality and fairness, or at least consistency across the Commonwealth. So something to think about if there's any rules related to or guidelines related to concurrent consecutive, it should be considered. So those are the key things that I wanted to sort of remind you about. And then let me just give you a sort of looking into the future being the next day. So tonight we have a dinner meeting. We start at 6. It's open to the public in terms of the old rules, which is anytime we have a meeting that we're talking about commission business, it's open to the public. So we're at the Hilton, it's open to the public, it's published. We don't provide meals for others, but commission members will, have dinner. And then after the dinner, we'll have just a discussion of what we talked about today and any next steps, an informal discussion of that. Tomorrow morning, we start at 9 o'clock with the policy meeting. And from 9 to 11, we'll conduct that, Judge Bernstein chairing that. And just to give you a little break from 8th edition sentencing guidelines, there's some other important issues that are on the table. And so we want to make sure we talk about those tomorrow morning. I think the leading thing is that just recently the House of Representatives passed a resolution 111, sponsored by Representative Stevens, that requires the commission to do a very detailed study of issues related to firearms and violence. This is important stuff. And we've been working on this for a while, and we've done some work in preparing for this kind of study. So Matt and Miranda will provide sort of an overview and an update of what we've done so far and what we expect to do, and just provide an opportunity to discuss it with the members. But I also want to mention that there's other bills out there moving through the General Assembly, and certainly bills related to violence and firearms. And a number of those would recommend either something related to the guidelines or something related to mandatories to try to address some real substantial violence in communities, and whether sentencing issues can be used in some way to help address concerns like that. So we'll add that to the discussion tomorrow morning, a couple of the bills that are moving through the General Assembly. A second thing that we'd like to provide an update on are the parole guidelines. As you know, a year ago, we held public hearings, and we at least put out preliminary parole guidelines and recommitment ranges for use at the state level. And then we suspended our work because the Department of Corrections decided appropriately, I think, to move towards adopting a new risk assessment for use within the institution, a new generation one, a strong R to replace the LSIR. A great move, but it takes a lot of work and it takes a lot of time. And there's going to be more delays on implementing that. And so one of the things to consider is, should the commission move forward with parole guidelines and recommitment ranges should we at least take them back to public hearings with some modifications based on what we heard and get that moving? Because we had really positive engagement with the parole board and with the Department of Corrections in building what we did and having public hearings. And we've been sort of in stasis for the past year. We've worked with the department on the risk assessment stuff, but there's no action on this. And we still have a mandate to do parole guidelines. So tomorrow we'd like to sort of have Brett review some of that, sort of what we've done in the past and where we are, and get a sense from the commission of, what our next steps are. I'm really happy that that the new acting secretary of the Department of Corrections, George Little, who may be with us now, but I don't know, but I believe he's going to be joining us either for dinner tonight or there's the secretary. Hi, Secretary Little. Really thankful to have him joining us. And that's one of the discussions we can have about, how are things moving along and what is his recommendation or the department's about how we should proceed, because I do see a lot of good in us moving parole guidelines forward, but I also appreciate that there's a lot of benefit of using a new instrument and not the current one. So just a good discussion point for the future. And Secretary, I don't know if you wanted to say anything. First, welcome to the commission as an ex officio member.
It is good to be here with you. I'm looking forward to meeting fellow commission members this evening. So I look forward to the discussion tonight, and I'll share more about where we are tonight and as appropriate tomorrow.
Sounds great. Thank you, Secretary. Appreciate it. And then the final thing, well, there's probably tons of other things, but the final thing that I'd like Matt to take the lead on tomorrow, he talked last meeting about all of the work on rebuilding the Sentencing Commission's website. And at that time, it was a future event. We were waiting for it to be deployed. Well, it is live now. We continue to work on it, but we've gotten really positive reviews, a lot of hits. And so Matt's going to revisit that just to sort of give a refresher on what we've done. Like I said, there might be other issues there, certainly thinking about our resentencing guidelines, things like that. But we'll have a jam-packed policy meeting for the first 2 hours. And then the business meeting, the quarterly meeting, should be pretty straightforward. Not a lot of action items. We have to develop our calendar for next year, and we have to decide what we're going to do with this proposal, these 8th edition guidelines. So it's a lot to think about. I'll be heading your way in minutes to join you for dinner this evening, and then I'll be back virtually tomorrow for the meeting. So thanks for all that. I'm going to turn it back to Judge Bernstein.
Okay, thank you. And just Representative Stevens, if you're still on there also, just a couple of questions that I have, because this is a lot. And so tomorrow, I think you're asking us to vote on whether or not we want to send what we have as a draft out for public comment. Is that correct? So my question is, what all does that encompass? Does that include the new matrix with the new OGS and the new PRS? Does that also include the adjustments and enhancements? Does it also include lapsing, concurrent, consecutive? So what are we looking at putting out there?
Yeah, I'd say the entire package. So we would, in effect, provide a preliminary draft of new guidelines, not final form, but highlight changes to the text of the guidelines, but then provide the information on the preliminary assignments that we would have for the OGS assignments, certainly the matrix that goes with that, and then the document that has the adjustments and enhancements. So the individuals looking at it would have sort of an outline or the sort of the text of how the guidelines operate, sort of like the text of the current guidelines. And then they'd have the tools, the information on the offense gravity score assignments, the prior record score process, lapsing provisions related to that, and the adjustments and enhancements. They'd have all of that to look at and to comment on. So that would be, so anything that the commission would approve to be in that package, we would put in there. We'd vet it with the chair and vice chair to make sure it's appropriate to publish, that it looks, that it communicates what we want to in terms of getting comment. And then that's what would be published along with any kind of hearing dates. And that's something else we can talk about tomorrow or this evening. How many hearings would we want? We've talked about sort of spreading them around the Commonwealth, maybe visiting with some counties. So those are all options on the table.
And then should we at the policy meeting tomorrow morning, I guess people who aren't joining tonight can email with concerns or thoughts or things they'd like to see happen to you. Is that correct?
Yeah, they're welcome to do that, but we can briefly talk about it in the morning with the policy meeting, but during the commission meeting, because it's a pretty pretty slight agenda, we'll have an opportunity during the policy discussion of the commission meeting to revisit all of this and sort of figure out formally what are our next steps. So that's why tonight is sort of an informal discussion, and there's an opportunity in the morning for members to talk informally among themselves, so that at the commission meeting at that section, we can decide how we want to proceed, or how the commission wants to proceed.
So, and I guess I'll let Representative Stevens speak because he may be asking what I'm going to ask. Go ahead, Representative Stevens.
Well, you could have gone at you're the chair. Thank you, though. I just want, I know we have, I think we have some new members on the commission who may not have been through this type of process before. And the one thing I do just want to convey, not only to them, but anybody else who might watch this video, that, when we put out a preliminary proposal, it's, I know some entities put out a preliminary proposal, and that's sort of it's the expectation that will be the final proposal and that there won't be any changes made. And that's not how this body works. I mean, we legitimately put out a preliminary proposal and seek feedback from practitioners and groups across Pennsylvania, and make sure that there's ample opportunity for all of those varying positions to be heard. And in the past, I've found that to be very, very helpful. I mean, we obviously have some very bright members of our staff and members of the commission who have offered already a lot of great insights to, I think, improve the product that we have. But I certainly think that every time we've gone through this exercise of public hearings, we have heard from folks that have offered some additional insights that we didn't contemplate or consider, and have incorporated them into the final product that was ultimately adopted by the commission. So I want to make sure that people understand that the expectation is that there would be changes from whatever we put out based upon the feedback that we get from practitioners and groups from across Pennsylvania during the public hearing process.
Any thoughts or comments based upon that? And I just concur that what I'm hoping is when we put it out to the public, that they understand that that's what this is, because I've been to the public hearings before where I feel like the people are walking in defensive for whatever side they stand on, and not recognizing that this is the beginning, and as a result of their input, because of this and other input, that we'll put something together collectively and move forward. That was for the same.
And Judge, to that point, and to Representative Stevens' point, which I think is a great point, just think about what we went through with risk assessment, and it was contentious, but I think we had maybe 4 different iterations of the risk assessment that we had public hearings on. And as the representative said, that the first thing we put out were basically, it was a draft, it was an outline, it was sort of a general proposal to solicit comments. And the difference between what we initially put out or had as part of the framework and what the final product was sort of night and day. And so this is part of a process, but we have not publicly engaged on this, and these are big changes. And so having a process where we put something out so people have something to hit against, something to make comments on, I think is a really positive approach. And I think we have a lot of good stuff here, but there's certainly, there's big changes in some of this, and we should hear the good, bad, and indifferent about those things, and try to move this along. And let me just put in one more plug, and I mentioned this before, but with the secretary on the call, when we did the parole hearings and we did guidelines for those, we had the great opportunity to virtually connect with the department, with I think 4 of the institutions, maybe 5 of the institutions, and working with the department and identifying individuals in the institution, inmates to testify and to be engaged in the discussion. I thought that was an incredibly positive process, especially because it was about parole guidelines, and they were individuals that were impacted by whatever we were doing. And I think that kind of connection with the department and remote involvement of inmates in public hearings on sentencing guidelines is equally important. So I hope we have an opportunity to do that. It was a really worthwhile thing. The department did a ton of work in helping to make that happen, but I hope we can do that again.
I'm sure that we'll be able to.
Thanks, Secretary.
Right. I think that's everything, correct? So